We need to talk about, your team was gonna do a little research on grand jury secrecy in the state of Georgia. Any updates?
Yes, so I did receive a couple of cases from the defense. We did do some searches last night. I did read the case law. I understand their point. And in Georgia, there is no right that the state has to prevent any witness from ever talking in perpetuity, is kind of what the law says. And the Butterworth case in particular deals with a reporter, a journalist that testified before the grand jury. And I understand that the defense is concerned about the implication that could be left with the jurors based on the question that I asked. So I will ask the court to give an instruction, be kind, and understanding that really my frustration with Attorney Hudson was that at that time it was very in the infancy stages of the investigation. I was secretly trying to find this will, and I felt like his conversation with Mr. Maples subverted that attempt, which is why we immediately went to his office the next day with a search warrant to try to locate it. So I don't have an objection or anything if the court wants to give an instruction with respect to that.
Okay. Anything else from the state before we bring the jurors in? They are here. Juror 61 was here on time.
Yes, we heard. Very good news. Just a couple things real quickly in connection with instructions to the jury. And I know the court didn't mean anything. There was a comment that you made, though, in the presence of the jury when we called Mr. Sprinkle. He wasn't on your cheat sheet witness list that we provided you.
I call it cheat sheet?
That's what I call it.
Oh, okay.
I call it cheat sheet, just to refer you to the list of names that we provided. But he was on our master list.
I have no doubt that he was, and there was squawking from the defense, but on a different issue, not who is this person, and we didn't expect.
Right. I just didn't want the jurors to have the impression that it was a surprise when the court kind of said, "Oh, he's not on." Whenever the state calls somebody, he's not on my list.
I feel like we're not necessarily moving forward. I think the jury might share that perception, but I will refrain from. Internally, I will mourn the lack of progress, but externally, I'll be passive.
That's fine. For the record, Mr. Sprinkle was listed as witness number 13 as a will call to testify summarily about phone records of Mr. McIver, and he was on the state's list, state summary of relevant testimony of witnesses that was filed February 26th.
Okay, and I didn't doubt he was on one of the several lists, and to repeat, I think the record will show no objection from the defense as to Mr. Sprinkle being called as a witness. The concern Mr. Harvey had was these photos I haven't seen before. Why are these coming in just now? Is he the right witness? And we worked through that, and the record was made, but there wasn't, and there shouldn't have been an objection from the defense that this was a surprise witness. Maybe just some of his content was unexpected.
And very quickly, Judge, would you hear from Mr. Wakefield regarding the motion to quash, just so we can get on your radar about it, because those witnesses, we expect to get to them in the next day or so.
Okay. An update on the motions to quash.
Good morning, Your Honor.
Good morning.
I don't believe we have the attorneys here for the affected parties, and it is their privilege, but I would like to just go over sort of where I think the lay of the land is right now in light of what we talked about earlier with the Morris Communications case, and when we discussed this issue, I know it must feel like 100 years ago, but it was just last week. Essentially, from what I understand, we have one journalist who said they were going to waive the privilege and testify. That's Mark Whitney.
Mark Whitney says he will testify.
Yes.
Okay.
So that the privilege is no longer a problem because it can be waived, of course, by the
What would he be? I don't know that you were here. You may have been, but you weren't at the podium the last time. Well, two things. One, we did talk about it real briefly yesterday, and in fact, Ms. Counts was here yesterday. She had been asked by the state to be here at a time when, unfortunately for her, we couldn't hear from her. But the last time your colleagues talked to me about Mr. Winnie's connection to all this, They didn't think they needed him. It was going to be a press play on the interview, and so it shifted from being a privilege concern to Mr. Samuel had raised the specter of 106, and what does that mean? But I guess if Mr. Winnie's going to testify, that might address a 106 side of things too. I don't know, and I don't need to decide that right now. But you're saying there are now 2 reasons not to worry about a motion to quash anything relating to Mr. Winnie. 1, what I heard before, we just want to play the interview. But 2, Mr. Winnie's willing to come on in and testify.
That's my understanding right now, Your Honor.
Is he spreading that good cheer to his colleagues?
Unfortunately, I don't. As of right now, I believe he's the only one who is feeling particularly cheerful.
All right.
But we do believe that it is Mr. Diggs, Morris Diggs of Fox 5, I believe, who we just want to play that video. That's the one that if the defense will stipulate to the authenticity, which we don't believe. My understanding now, of course, could be corrected. That should be a problem. But that's the one where we believe we just want to play the video.
Okay. And not ask Mr. Diggs any questions?
Yes.
Okay.
With regard to...
Excuse me, is Winnie just asking to play the video also?
Yes. Yes. Just play.
So what would Mr. Winnie need to take the stand for then?
If you don't have
Beyond that, which is why I thought there'd be this ripple effect of then Diggs would say, well, then me too. Gotta get all the networks on there. But either way, you're gonna manage your witnesses. You're telling me that, and I think it was a different firm, it was Ms. Gaither and Mr. Clyde who represent Mr. Winnie and Mr. Schneider.
Yes.
But they had filed a nearly identical motion to quash. That's moot now, because Mr. Winnie is willing to come in if you need his testimony. And Mr. Diggs, you don't need anymore, provided there's not an authenticity issue. Okay, so that leaves us Hobbs and Schneider.
Right, the two actually written articles. With regard to Mr. Schneider, who I believe now lives in New York State, the state simply needs the article. We would like to submit the article as evidence. And so Mr. Schneider's testimony is not really essential to the state's case. With regard to Ms. Hobbs, that is a question that will, in due time, the need for that will be revealed, because that was an interview with Mr. Crane. If Mr. Crane's veracity is attacked, then it would be a rehabilitation exercise to try to get Ms. Hobbs to say, what were you told about Bill Crane?
Okay.
Is it reflected accurately in this article?
And I've always understood that to be the case, that that's how Ms. Hobbs would need to be involved. There was some discussion of, well, you know, if there were emails back and forth, maybe that would resolve it, but I guess it's really a conversation for your team to be having with Ms. Counts,
Yes.
who represents Ms. Hobbs. It didn't sound to me so much like it would be getting into privileged area so much as almost procedural. Could you just describe, Crane handed me a piece of paper or emailed it to me, and I typed it in, and that was the article.
Essentially, what we're going to be arguing that we're in the Morris Communications world, where this is information that has been published. So the privilege has been waived and no longer applies. Ms. Hobbs' testimony would essentially be that Crane was there as a representative of the defendant and that he was relaying information from the defendant. That's the whole reason why the interview was taking place. So it's not going to go into, well, what else did he tell you? You know, was there some secret confession that he relayed to you that you for some reason didn't post?
Right.
We're not going beneath the surface of what has been published, and therefore the privilege is not in effect because we're in waiver territory.
Do you
I'm sorry,
We are in waiver territory. Apologies.
Do you know that it was even an interview? The part I don't fully understand yet is the way Mr. Crane and Ms. Hobbs interacted. It's not clear to me they were even ever face-to-face. That doesn't mean they couldn't have been an interview, but the structure didn't sound so much like an interview as, here is the statement that I'm making on behalf of my client. Not as a lawyer on behalf of my client, a publicist, call Crane what you will. And this is the statement, start, finish.
I can't speak to all the details on that. You're right, Your Honor. It's not been entirely clear what the whole process was. I believe, of course, Mr. Crane will be able to give some detail on that. We can also speak with Ms. Counts to try to get an understanding beforehand. And I apologize for not having all those details at hand right now.
Okay, well, I think you're right. It starts with Mr. Crane, and that will tee it up a little more clearly as to what Ms. Hobbs might have to say about it.
So that I'm understanding Your Honor's position, if it was an exchange of emails or never a face-to-face, simply a, here's the black and white, something like that, are you suggesting that we need to look at whether the waiver applies in more detail? Would that change the appraisal of the waiver?
No, I'm not suggesting anything other than it seems like if Hobbs was merely a conduit to the printed page, I don't know that there is any waiver in the mix. But if there was an interview, there was massaging, there were things not included, there was some editorial work done by Ms. Hobbs, then this requires more examination. Crane will be able to give us some insight into that, and then ultimately perhaps Ms. Hobbs. But this seems to be less in the wheelhouse of the privilege than Schneider's article, because as I understand that, there are quotations, and then there are things where Mr. Schneider says, this happened and that happened, and there aren't quotations around it. And we don't know who the sources of information are on that. We don't know if, let's say the sources were Mr. Maples and Mr. McIver. They said 17 things to Mr. Schneider, and he distilled them to 5 things. That process, I think, is getting you into the heartland of what would be privileged. But you aren't interested in putting Mr. Schneider on the stand and asking questions about that. Your team, and they may get you involved, will need to work through how is it not hearsay or whatever other objections the defense might have to getting into evidence some or all of the article.
Thank you, Your Honor.
I appreciate the update.
Yes, sir.
Anything else from the state? Okay. Defense. I will, unless you have had a change of heart, start this morning by telling the jurors, insofar as they recall it, there's no grand jury secrecy, there was nothing untoward about the fact that Mr. Hudson spoke with Mr. Maples, or that Mr. Maples asked Mr. Hudson questions. It's not at all inappropriate, it's how things happen as cases are evolved. That's something you still want to have said?
Yes. Yes, good morning.
Good morning. Okay. I'll do that. Mr. Samuel, we are fast approaching where these media witnesses become a situation you need to give me your thoughts on. Having heard that with Diggs and Winnie, the state has got to the point where they just want to press play on an interview, what are you thinking?
I'm thinking I gotta look at them and talk to them over lunch.
Okay, I appreciate you doing that. I guess I'd put Schneider in the same category. It's not press play, it's here's the article. And so if you would be thinking about those 3 and then talk with, who is the right person so Mr. Samuel knows who to corner? Mr. Humphrey got pointed at. Okay.
Yes, we've already been talking, and I've actually got the media on the jump drive for them, so they can just confirm what it is we'll be pressing play on, and we can hopefully get on the same page.
You and Mr. Samuel seem to work well together. Let's
Yeah.
continue to explore that. And then with Ms. Hobbs, I really think it's going to be reactive to what Crane says, how Crane is handled on cross, and then we'll be in a better position. And that's going to be tricky for Ms. Counts, but maybe the report will make it happen. ALM, I think is. All right, anything else from the defense?
I think we'll be hearing from Mary Radford this morning, and we talked a little bit about her at our pretrial hearing, about...
She the professor who's going to talk about wills?
Yes.
Okay.
So just while we're here, I'd like to get my objection on the record. Assuming you let her testify, I can just renew it when she starts to testify.
Sure. And as I'm recalling, Ms. Radford isn't someone who generated a report so much because she wasn't able to have a new will to look at to say, here's what it means and doesn't mean. I'm looking at you.
She wrote a report.
But she did write a report.
I have it.
Okay. There was a relevance issue or the report came too late?
I think back then the objection was more, it came too late. So now I would add relevance and 403. Waste of of time and cumulative under 403. My understanding, she's going to be comparing Mr. McIver's 2004 will, 2005 will, Diane's 2006 will, the suggested changes we saw in the emails with Mr. Hudson, and then Mr. McIver's 2016 will. So some of it, I don't understand the relevance. Why are we going back to look at his 2004 will that was superseded by a 2005 will? But it's really more, cumulative and waste of time, given that we went through this with Mr. Hudson.
And notice some of the jurors sporting 403 tattoos, just so you keep that in mind as we move forward. I think that's a fair observation, in particular maybe about the 2004. And so what I'd ask you to do is, if you feel, I'll stay on that like I promised Friday and Monday morning. I'm going to be patrolling a little bit more that, look, we've already been there, let's move along. And I think this is a good witness with which to do that to a certain extent. We actually have heard very little about the wills. We've heard a lot about was there a will, etc. But the operative clauses of the wills, really we've only had one witness talk about that in much detail. So cumulative, maybe not so much relevance. If 2004 was replaced by 2005, I don't know why we talk about 2004. But there could be something in there that the state wants to zero in on. If it starts to get too general, I'm probably going to say, let's move it along. But I invite you to do the same. But I don't want you to feel, I'm going to look like I'm trying to hide something. That's not the burden I'm putting on you. That will be a reminder to me as well. Wait a minute. We do need to get on point to the two wills that really are more germane to what we're working through.
Okay, I'll do it.
All right, great.
That's it.
Thank you. The jurors have designated today as another 6 o'clock day, but in a nice note, they can put a heart on it. They said, well, we can stay till 6. If there's a natural break point before 6, we're okay stopping. That's a point well taken, and I think we'll try to make it work that way. We'll just see how things flow. Okay? Bring the jurors in. Please be seated. Thank you, Deputy Murphy. Good morning, ladies and gentlemen. Good morning. Special good morning to 61. Here on time. Way to go. I got your note and shared it with the attorneys. It is a 6 o'clock night, but if there is a natural break point before then, we'll call it a day then. We'll just see how things are flowing, but it doesn't need to be a forced march today. We had to cover a bunch of things this morning to try to make the day a little more streamlined, so it was helpful to get input from both sides. Before the state calls its next witness, I need to draw us back to yesterday, late afternoon, early evening. Mr. Hudson was on the stand, and at one point, Mr. Rucker asked a question about grand jury testimony and why did you talk to Mr. Maples about it? I don't remember exactly the question Mr. Rucker asked, but it may have created in your mind the impression that there was something improper about someone who gets in front of a grand jury to leave the grand jury and go talk to someone about what that person said in the grand jury. And it's important for you all to know, if that was the impression you got, that there is no grand jury secrecy here in Georgia. So if I was called in front of a grand jury to answer questions, I could leave that grand jury and tell the media if I wanted to. I could tell someone else. Nothing wrong with an attorney who might have an interest in what's going on in front of the grand jury to approach that witness and say, hey, what'd you talk about? And for them to have that discussion. So it may not have hit your radar at all, but in case it did, I didn't want anyone to take away from it that Mr. Hudson had done anything inappropriate. And I think it was Mr. Maples he talked to, that Mr. Maples had done anything inappropriate, that the two of them had a conversation about what Mr. Hudson may have said in the grand jury. That may have been something that frustrated the state, and they may have legitimately been frustrated, but there are things that are legitimate that can frustrate someone else. So it was a long way of saying it wasn't an issue that Mr. Hudson put down. And we will proceed. Mr. Rucker, state's next witness.
state will call Mr. Kenneth Rickert to stand.
Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir. If you will, have a seat. Get as close to the mic as you can during your testimony. For the purposes of the court's record, please state and spell your name.
Kenneth Rickert, Kennethrickert.
And good morning, sir.
Good morning.
Would you please turn and introduce yourself to the jurors? It's okay if you look at them when you
Yes.
give your testimony. And tell them your name and how you are currently employed.
Kenneth Rickert. I am currently employed as General Counsel for U.S. Enterprises.
And can you explain to the jurors what are some of your duties and responsibilities as General Counsel?
I'm responsible for all the legal issues that come up with the company. We get involved in anything from general contract work to aviation. We have a corporate jet. We deal with real estate law, compliance issues, anything that comes up in a small company, litigation.
Okay. And can you tell the jurors how long have you been employed at U.S. Enterprises as General Counsel?
I have been there for 26 years.
Okay. And could you share with them a little bit about your educational background that allows you to perform your duties there as General Counsel?
I graduated from the University of Virginia with a BA in economics and received my law degree at Emory University.
Okay. And you are, of course, licensed to practice law in the state of Georgia.
Of course.
And can you tell the jurors, in your career there at U.S. Enterprises, where are you in the pecking order if Mr. William Corey is at the top?
When Diane McIver was alive, I reported basically to Diane and Mr. Corey.
Okay.
But I worked probably closer to Diane because she did the day-to-day operations of the company. Mr. Corey was kind of the overseer, but Diane dealt with all of the everyday items that came up. So I worked probably closer with Diane.
Okay. And can you share with the jury, how would you characterize and describe your professional relationship with Diane McIver?
Very good. I think we had a respect for each other. We had worked together for 24 years, and Diane was difficult. She was a tough taskmaster. She demanded a lot, but we had a mutual admiration.
How would you describe her as a businesswoman?
Tough. She was very astute, very street smart. She was a hard-working individual, and she achieved a lot in her life.
Now, we've heard a little bit about her sharp tongue. Are you familiar with what I'm talking about if I ask you about Diane McIver's sharp tongue?
Everybody that worked at the company knew Diane had a sharp tongue. She could throw zingers in there at any time, sparing no one, including Mr. Corey.
Okay. Can you share with the jury, did you have a relationship with Diane McIver that extended outside of the professional circle and spilled over to a personal or social relationship?
We, somewhat, but I would not consider myself a good, close personal friend of hers. It was more of a business relationship.
Okay.
I would do some things when we needed to do corporate functions. My wife and I would attend certain things, and we did, I think on 2 occasions, go on a vacation with Diane and Tex. Once we went to Napa. Once we went to West Point to a football game for the weekend. But other than that, I'd see Diane and Tex on a social basis maybe once or twice a year at most.
Okay. And can you tell the jury, did you come to know the defendant in this case, Mr. Clark McIver?
Yes, I did.
And how did you come to know him?
I first met Tex when Diane was dating him, and as she dated him, she would involve me in some of those things. We went to Chastain Park on one occasion, but then they got married. We went to the wedding at the ranch in Eatonton.
Okay. And based on the kind of relationship that you had with the McIvers, would you be a person who would frequently visit the ranch?
No,
Okay. Or frequently come by the Atlanta condominium?
no.
Now, can you tell the jurors, was there a business relationship between U.S. Enterprises and Claude McIver and Fisher & Phillips?
Tex was a partner at Fisher & Phillips, and Fisher & Phillips had been a long-time labor law firm that did labor work for us ever since they actually had been doing labor work for us before I got there to the company. When Diane married Tex, we got involved in litigation. It was very complex and protracted litigation against the city of Atlanta and Clear Channel. It went on for probably close to 10 years. And during that 10 years, we had numerous firms that represented us. Fisher & Phillips probably took the lead in that. In many instances, they didn't do the actual trial in federal court. They were not lead counsel, but they were very much involved throughout the litigation. And I'd say probably over the 10 years of that litigation, we spent over $10 million in legal fees. It was very expensive. We were successful in obtaining a judgment in a federal, I don't know whether this is more than you need to know, but...
Well, yeah, I'll stop you right there. But,
okay.
But the gist of it is, because of the work that Mr. Phillips did while Mr. McIver was a partner there, generated roughly $10 million in fees.
And that's just a guess, but it was significant.
Okay. Now, can you share with the jurors, in your capacity as an attorney there at U.S. Enterprises, from time to time would Diane McIver ask you to perhaps do legal things for her personally or any of her various businesses?
On occasion.
Okay. And I want to draw your attention to, well, strike that. Let me ask you another question. Did you know Diane to make loans to people?
Yes.
Okay. And could you describe for the jury what you knew about Diane McIver making loans to people?
She was generous. If her friends needed money, she would help them and make loans to them, various amounts over the years. She'd ask me to prepare a promissory note, and I would do that. She'd give me the parameters, the interest rate, how long, whether it was principal and interest, that type of thing. Okay. And I would prepare the document, and she, I assume, made the loan.
Okay. With respect to the loan she'd make to her friends or anyone, she would make sure it was in writing.
Yes.
As far as you knew.
Yes.
And there would also be interest associated with it.
Generally, that's right.
Mm-hmm. And there would be real specific parameters about how the loan was to be repaid.
Yes.
Okay. Let me show you a series of documents. They have been marked, Your Honor, as State's Exhibits number 427, 428, and 429. I have shown them to defense counsel previously. And Mr. Rickert, if you would take a look at all three of those documents and indicate for us whether or not you recognize and can identify them.
Yes.
Okay. And can you tell the judge and the jury how is it that you recognize and can identify them?
They were prepared by our office.
And can you describe for the judge what is 427?
It's a promissory note dated March 1st, 2005 in the amount of $750,000.
Okay. From whom to whom?
It was from Claude McIver to Diane, Claude being Tex.
From Claude?
The money was lent by Diane to Tex.
Okay. So the money, the $750,000 was from Diane to her husband?
Yes.
Okay. And the date of that again for the judge?
March 1st, 2005.
Okay. And what is 428?
428 is a promissory note in the principal amount of $350,000 dated December 23rd, 2011. The loan was made by Claim Management Company to Tex McIver.
And can you tell the jury, Claim Management Company, what is that?
It was a company Diane owned. She was a sole owner.
Diane was the sole owner of that company?
Yes.
Okay. And State's Exhibit number 429, what is it?
429 is a renewal promissory note in the amount of $350,000 dated December 22nd, 2014. And again, this was from Claim Management Company to Tex McIver.
And in taking a look at those documents, does it appear as though there have been any alterations or changes or deletions, additions to the document itself?
Let's see.
Any pages could be missing?
There was a change on the first $350,000 note, and it looked like the date was changed from the first day to the 5th day of the month, as far as the date that payments were due.
Okay.
There was no change in the other one.
Okay. At this time, Your Honor, I will tender in the evidence State's Exhibit 427, 428, 429.
No objection.
They are admitted.
Is that zoomed in well enough that you can see it, Mr. Rickert?
Yes.
Okay. Here we have in this corner of the screen, what is that?
It's the dollar amount numerically written out, $750,000.
I'm sorry. There was some noise in the back. I just didn't.
$750,000.
Okay. And this is State's Exhibit 427. And this is the March 2005 note, right?
March 1st, 2005, yes.
Okay. And could you please just, for the benefit of the jurors, if you would just read this first paragraph here.
For value received, the undersigned Claude L. McIver III, hereinafter referred to as Maker, promises to pay to the order of Diane Smith.
Slow down, just a little bit for the jurors.
Here,
Court reporter.
He's going to read that whole paragraph?
Well, just one paragraph, Judge.
Okay.
Yeah.
All right, I'll start over again.
Yeah, the court, even though that's in evidence, because you're saying it now, the court reporter has to take it down word for word, so.
I will.
Slow and sweet, please.
I will. For value received, the undersigned Claude L. McIver III, hereinafter referred to as Maker, promises to pay to the order of Diane Smith, hereinafter referred to as payee together with any subsequent holders hereof, hereinafter collectively referred to as holder, close paren, without grace at the mailing address of payee at 225 Corey Center Southeast, Suite 1, Atlanta, Georgia, 30312, or at such other place as holder shall designate from time to time in writing the principal sum of $750,000 in no 100, then parentheses 750,000.00, together with accrued interest thereon at the rate it's all blurry, at the rate hereinafter set forth in lawful money of the United States of America, which shall at the time of payment be legal tender in payment of all debts and sums and dues.
Okay. And on the back page, and you recognize that signature?
Yes, that's Tex, Claude McIver, Tex.
Okay. And over the years, you had done work with Mr. McIver, his capacity as a lawyer, Bishop Phillips.
I have.
And did you come to a place where you have seen his handwriting and his signature on other occasions?
Absolutely. I mean, he's sent me thank you notes from time to time. He very gentlemanly in that, but he sent me thank you notes, and I know his writing.
You know his writing, okay. This is State's Exhibit 428. And this is what you told us is dated December 23rd, 2011, for $350,000. Note secured by real estate. Is that correct?
Yes.
And can you tell the jury, without reading the whole first paragraph, what real estate was this note secured by?
This was a loan that she made to Tex, and it was secured by a security deed out on the property in Putnam County.
Now, on the second page, could you tell the jury, with respect to this note that was secured by the deed for the property of Putnam County, was there a provision in this promissory note that provided for what would happen if Mr. McIver was unable to repay this $350,000?
Well, it was secured by a security deed on the property, which would give theoretically Diane the ability to foreclose on the property if there was a non-payment. I'm not sure that that would have ever happened. Diane would have avoided that, I believe, at all costs, to try to keep the marriage together, certainly. But she had that right to foreclose.
Okay. Now, would Diane ever speak to you about the personal details of her marriage to Mr. McIver?
No, she was a very private individual. She really didn't speak to me about her personal life very much at all. I was surprised when she got her first divorce, when she went through that. I had no idea that was coming.
Right.
But she was very private.
And how about her finances? Would she talk to you about what was going on with her finances?
Same thing. She was extremely private about that. Kept it all to herself, and that certainly I understood that.
And could you tell the jury, was she kind of the kind of person who, when she made loans such as this, she was not very serious about making sure she was repaid? She that kind of person?
She expected to be repaid. I mean, certainly, Terry Brown, who was her assistant, was responsible for making sure that everyone paid on time. If they didn't make a monthly payment, she would send out notice. She would make them pay, even though they were friends.
And can you tell the jury what was the term for this December 2011 promissory note to be repaid? Do you know?
I believe it was the 3-year note, but as I recall.
Okay. Repayment was due in 2014 then?
I believe so.
Okay. And Mrs. States, 429. This is the note you testified to, dated December 2014, and it's titled Renewal Promissory Note. Could you explain the relationship between this promissory note with the previous one we just looked at that was secured by the ranch?
Tex had made all the interest payments, but the note was due. He could not pay the $350,000 off at that point in time. He went to Diane. I just strike that.
Well, yeah, because that wasn't assumed. But let me ask you better with a question. Were you asked to prepare a renewal promissory note for Diane McIver?
Yes.
Okay. And this renewal promissory note reflects that work that you did?
Yes.
Okay. And can you tell the jurors, with respect to this December note, is it still secured by the deed to the Putnam County property?
Yes.
Is interest still required to be paid on this note?
Yes.
Okay. And can you tell the jurors, is the interest rate the same in this renewal note as it was in the previous note?
It was slightly less on this note, and the only reason that I know that is I remember Diane said when I prepared this promissory note, I noticed that the interest rate was a little bit different. I said, why are you reducing it? She said,
Now
well,
stop
tax.
for a second. I want you to tell us what she said. But she did give you an
She
explanation.
did give me, she wanted to reduce the amount, yes,
Okay. Of the interest rate.
of the interest rate.
Okay. And this renewal promissory note is due to be paid in full when?
December 21st, 2017.
And it's also signed by?
Signed by Tex McIver.
Now, can you tell the jurors, this December 2014 note, at the time that this note was signed by the defendant, do you know what his status was at Fisher & Phillips?
He was a partner, as far as I know.
As far as you knew, you thought it was?
I had always dealt with him in his capacity as a partner.
And can you tell the jury, do you recall having some discussions with an attorney by the name of Harold Hudson somewhere around 2009?
I do.
Okay. And can you tell the jury, generally speaking, what were those discussions about?
Diane asked me to attend a meeting at Mr. Hudson's office, who was representing Tex. She was in the process of changing her will. She wanted to revise her will, previous will, and asked me to attend that meeting.
Okay. And can you tell the jurors, when you got to the meeting to talk about revising Dinah McIver's will, is that what was discussed?
No, it mainly centered, as I recall, at that time, it was centered on Tex had a company called Austin Agribusiness LLC, and they presented us with a lease. Tex wanted to have the farm, Diane and Tex would lease it to Austin Agribusiness. It was a tax planning.
I'm sorry, say that again. Repeat what you just said for that sentence.
Austin Agribusiness. Is that what you need?
Yes.
Okay. It was a tax planning vehicle for Tex, and it would have allowed him to write off expenses at the ranch. And I told Diane it was not to her benefit to do that, in my opinion. She would not benefit at all from it. So she did not sign it to my knowledge. And we had some discussion at that meeting about the revision to her will. Diane at the time wanted to make two main changes, if you want me to go into this
Yes,
now.
please tell us what the two main changes were.
She wanted to,
I know we have the email that's in evidence. Are we talking about 2009 or 2011?
I don't know when, it was in that period sometime when we had the meeting with Mr. Hudson. I'm not sure of the exact date.
So my objection is hearsay. I know we have an email that's in evidence from Mr. Hudson, which I guess we could go over with this witness, but if he's going to relay something different about the meeting, my objection would be hearsay.
Okay.
One question.
Sure.
These changes that Dinah McIver talked about, were they talked about in the presence of Mr. McIver? Did it happen during the meeting?
Yes.
Okay. And Mr. McIver would have been in a position to hear the two main changes that Dinah McIver wanted to make to her will?
Yes. Yes.
Okay. So I would ask that the witness be allowed to testify to that when those statements were made in the presence of the defendant.
I have the same objection.
Okay. I think it's still hearsay. It may be that we're all talking about the same thing with the emails, and that may become clearer perhaps after cross-examination, but for now, we'll have you move elsewhere.
Okay. As a result of what was discussed at this meeting, And by the way, how many meetings were there between yourself, Dinah McIver, the defendant, and Mr. Hudson?
I only recall one.
One. And at this one meeting, is that where Dinah McIver would have talked about the two main changes that she wanted to make to her will?
Could you restate the question, because
Yeah.
I don't really understand.
Okay. While you were at this meeting, did Dinah McIver discuss the two main changes that she wanted to make to her will?
It's my recollection, we certainly talked about one of the changes, and I believe we talked about both of those changes. But it was 7, 8 years ago, 9 years ago.
I understand. Because there were other exchanges between yourself, Dinah McIver, the defendant, and Harold Hudson regarding revising her will.
I know there were some emails back and forth during that period.
Now let me ask you this. Do you know who Austin Swall is?
Yes, of course.
Can you tell the jury what you observed with respect to Diane's feelings towards Austin Swall?
Diane never had children of her own, and Austin was like a son to her, grandchild perhaps because of the age difference, but she was very, very fond of him. She'd do anything for him. She was a shining light in her life.
And can you tell the jury, were you aware of Diane McIver's 2006 will?
Yes,
And you had the opportunity to read it yourself?
I am.
You're familiar with some of the contents?
I am.
Can you tell the jury in the 2006 will of Diane McIver, is Austin Swall named or mentioned in any way?
No.
Were you familiar with the defendant, Claude McIver's children? In particular, I just talked to you about Robbie. Did you know Robbie?
Yes, I had met him, I know I met him once. I may have met him more than that, but I recall at least once.
Okay. And based on your observations, can you share with us what you saw Diane McIver's feelings were towards Robbie?
They were not good. Diane did not like Robbie. She'd had some run-ins with him. It was unfortunate, but she had some problems.
Do I object, Your Honor? I think it sounds like we're talking about something that would be based on hearsay. I understood him to say you only met Robbie one time.
I think we just don't need to go any further. I think I'll leave it as is, and if you think there's a proper foundation for us to go further, we can go further through this witness. Otherwise, put a full stop.
I understand. The tax plan that you were presented by Mr. Hudson and the defendant, did it involve changing Diane's ownership interest in the ranch?
No, there were no changes at that point in time. She was a joint tenant with the right of survivorship. She had that right.
She was a joint. I didn't get it right. She was a
Joint tenant with the right of survivorship.
Okay. And in order for the plan to be signed, would she have to change her ownership interest in any way, if you recall? And if you don't, it's okay.
To accomplish what Diane wanted to accomplish, which was to give her interest in the ranch.
I'm sorry. Are we about to talk about what Diane wanted to accomplish with the changes to her will? Because if we are, then I object. I think the question was to do the tax planning Mr. McIver wanted to do, would there have to be changes to Diane's ownership of the ranch?
Right, that's correct. And not about the will. I didn't think it had gone into the area, but let's make sure it does.
Okay.
Yeah. You understand my question, Mr. Rickert?
I believe you're asking if the deed itself would have to be changed.
Yes.
Yes, it would have been advisable to change the ownership, in my opinion.
Okay. And so, let me make sure I understand. You were presented with a tax plan by Mr. Hudson, correct? At this meeting.
There was one document, wasn't a tax plan, there was one document that it was a tax planning vehicle, and we talked about changes to the will, but there was never a meeting of the minds between Diane and Tex.
Okay, okay. And your advice to Ms. McIver at that time with respect to the tax plan was what?
I saw no benefit for her, so I did not recommend that she enter into that agreement. It was a lease agreement.
Okay. Now, do you know if she created a new will in 2014 and 2015? Do you know?
I do not know.
And you yourself personally never prepared one for her?
I prepared a codicil, which is an amendment to a will,
Okay.
back in 2007. That's the last document that I had prepared in connection with her estate planning.
Okay. Let me show you State's Exhibit number 447. I've previously shown it to the defense counsel. Take a look at that document and tell us whether or not you recognize and can identify it.
Yes, this is the codicil that I prepared in August of 2007, which would have amended her February 1st, 2006 will.
Okay. I'll tender State's 447 there.
Any objection to 447?
Yes, as to relevance, since it's from 2007.
Okay. I'll allow it. The 2006 will is the one that was probated? That's what we heard, so, okay.
And this one is not executed.
Understood. Okay.
Thank you. Can you tell the jury, do you know what year Austin Schwab was born? Do you know?
No, I don't know around this time, but after 2006,
Okay. And this codicil was in 2007?
yes,
August? I'm sorry.
August of 2007.
Okay. And can you tell the jurors what were the changes that were proposed in this codicil to Dinah McIver's 2006 will?
Let's see.
Generally speaking, you don't have to, the document is in evidence.
She wanted to provide, the two changes were she wanted to remove one of the beneficiaries. She'd had a falling out with a lady named Kathy Johansson, and she wanted to remove her. I think she was under the 2006 will to get a significant bequest. And the other change was to provide for Austin.
And the change that provided for Austin, can you tell the jurors what was it?
She wanted to set up a trust for Austin, and it had provisions that would pay him a percentage of the trust value each year once he attained the age of 25.
Okay. And the trust was for Austin's what?
Well, I think it was intended to help him for his benefit. I mean, it was.
Austin Schwab's name is mentioned in State's 447, the codicil, correct?
Yes.
And there are also two other names. Do you know Tiffany Hugh and Devin Hugh? You know who they are?
I do. They're James Hughes' children.
Okay.
And I'm not. Oh, go ahead.
No. You know them to be James Hughes' children?
I know them. The last names may be different, but yes, I know them as James. I've met both of them.
Okay. And when you say the last names might be different, what do you mean?
There was a document that was in the file that had a circle around each of those names, and it had not correct name.
Okay.
So I'm not sure.
Okay. And this was in 2007, correct?
This document was 2007, yes.
Right. Do you know how old Tiffany Hugh and Devin Hugh were at that time? Do you know?
Probably high school.
Okay. And certainly since this time, you don't know whether or not either one of them have gotten married?
I had no idea.
Okay. And this part here, it says the trustee's judgment to provide for the post-high school education of Tiffany Hugh Devin Hugh, and Austin Schwab. Post-high school education includes college or postgraduate schools, professional schools, and any trade schools which Tiffany Hugh and or Devin Hugh and or Austin Schwab wish to attend, right?
That's correct.
This was the change that she made to her 2006 will.
That was one of the changes
Okay.
she wanted to make.
And can you tell the jury in reviewing the document, does Diane McIver in this codicil assign her interest in the ranch in Putnam County to Austin Schwab in 2007 in this codicil?
No.
And did she sign this codicil?
No, it was never executed to my knowledge.
Now, can you tell the jurors, after Diane McIver's death, did you look for any wills executed by her?
Yes.
Okay. And first tell us when you would have first done that, and tell us what you did.
So I recall on the Wednesday after Diane's death, Tex called and asked if he could get a copy of the will. Diane had some filing cabinets in her office that were locked. She kept locked, and she had her personal papers in there, and some business papers, it turns out, when we went through it later. But that's where I found the will file.
Okay. And would that have occurred on that Wednesday?
Yes, we had to get we had to get a locksmith to come over because we couldn't find the keys. Diane used to always have a big round keychain. She had millions of keys, it seemed like. And it was probably, I might have been in her purse. I don't know where her purse ended up the night of her death, but I did find in her desk some keys, and one of the keys got into one of the cabinets, but the locksmith was coming out anyway, and the other cabinet we couldn't get in, so he had to drill that one and open it up.
Okay. And you can tell the jury that you yourself personally actually went through that file cabinet?
The will file?
Yes.
At that time, yeah.
Itself.
I didn't go through the whole filing cabinet. I was looking for a will file to make a copy for Tex. So I didn't go through all the other documents at that point in time. That was later, but not then.
Okay. And the will file, can you tell the jury, what did it look like?
It's a normal manila file that most lawyers use. And at the top, it had a little green tab across it, and it had Diane Smith will on there.
Okay. And can you tell the jury, when you looked inside, what did you see?
Various documents, the codicil that I had prepared, the
one that was unsigned? The one that we just talked about?
Yes, the one that we just talked about. There was a 2004 will that Tex had executed that was, a copy of that was in there. His attorney that prepared that had sent a copy to Diane. It was on, his note was on there. There was a 2005 will that Tex had executed that was in there, a copy of it. And then there was the original of Diane's will, 2006 will, that was in there.
Okay. And can you tell the jury, was there also any copies of that 2006 will in there?
Yes, there were several copies in there of the will that she had made.
Okay. And so can you tell the jury when Mr. McIver called you and asked you for the 2006 will, did you provide him with it?
I did. As I recall, there was a lot going on then, and we were all still in shock too. Richard Harrell was a close friend of Diane's and Tex, and I believe I gave Richard a copy to take to Tex. He was going by the condo, I think, on a fairly regular basis.
Okay, all right. Your Honor, at this time, I would like to tender into evidence State's Exhibit 441. Understand that there is no objection from the defense.
Correct, no objection.
Okay, 441 is what?
It's the last will and testament of Diane McIver to
2006.
2006. Okay. Take a look at that document. And can you tell the jury, is that a signed and executed will for Dinah McIver in 2006?
Yes, it is.
Okay. And can you tell the jury what was your role with respect to this 2006 will?
My sole role in this was as a witness to the will.
Your signature actually appears on the document.
My signature appears on the document as a witness.
Okay. And were you also the trustee?
In this will, yes, I was named as trustee.
Okay. And can you explain to the jury what were or what are your duties and responsibilities as trustee?
Upon the estate being closed out, once the executor files all the paperwork with the probate court and the estate is closed, the residual value then, if there's any value left, would go into a trust, and the trustee would then administer that trust in a fiduciary capacity and oversee its distribution.
And with respect to the 2006 will, who was the executor?
Tex was.
And in this 2006 will, does Kathy Johansson receive a specific cash request?
Yes, as I recall, she received $100,000.
And are there any other specific cash requests?
Yes, James and Wanda Hugh were to receive $200,000, and Phyllis Gable, who was a housekeeper for Diane, was to receive $50,000.
Any mention of Danny Joe in that will, Danny Joe Carter?
Not with respect to a specific request. I'd have to look through. No, there was not.
How about Janie Calhoun?
No.
Can you tell the jurors, when you provided that will to Richard Howell to deliver to Mr. McIver, did you require a receipt?
Can I correct counsel?
Yes.
When I gave Richard Harrell a copy of the will, no.
Okay. So
When I gave the original will subsequent to that, I did require a receipt.
I'm sorry, I left that part out, didn't I? I'm sorry. On Wednesday after Diane's death, what did you actually give to Richard Harrell to give to Mr. McIver?
A copy of the will.
A copy of the will.
Tex just, he didn't ask for the original, he wanted a copy.
Okay. And so at a subsequent time, did you actually give him the original?
Yes. That following Tuesday, October 4th, Tex sent me an email. His estate attorney had requested that he obtain the original will. To file a petition for probate in the state of Georgia, you have to have two basic documents have to be attached to that, and that's the original will and a copy of an original death certificate. And Tex had obtained the death certificate, and then the final document he needed was the original will, which I provided to him on the following day, the 5th of October.
Okay. And at that time, is that when you received the receipt for it?
Mr. Corey at that time did not want Tex to come into the building, and I asked Richard Harrell I put the original in a manila envelope and asked Richard Harrell to go out in the parking lot when Tex came by and give it to him, and I asked him to have Tex sign a receipt for it.
Okay. Did you receive a receipt back?
Yes, Tex signed it.
Okay. This is States 448. You recognize the form identified?
Yes, this is the receipt that I asked Richard Harrell to have Tex sign when he picked up the original will.
I would tender States 448, Judge and evidence.
Any objection to 448?
No objection.
It's admitted.
Now, can you tell the jury, prior to your testimony here today, and specifically a couple of weeks ago, did you have the opportunity to come down to my office to speak with me about this case?
I did. You'd requested that we come down.
Yes. And can you tell the jury, when you came down, did you bring the will file with you?
I believe I did.
And can you tell the jurors at that time, did you provide me another document that was located within the will file?
Yes, there were several copies, as I mentioned, of Diane's will, and the front of the will is just like this. It's not, you can't tell whether there's anything else written on it inside by just looking at the front. I had assumed that Diane had made copies of the original will and had several copies in there. When a few weeks ago I was going through it and the file again, and I realized that one of these, what I thought were exact duplicate originals, copies, not duplicate originals, but copies, it actually had some changes that were on the will written on there, which I had not noticed before.
Let me show you State's Exhibit number 271. Do you recognize it? Can you identify State's 271?
This is the copy that I mentioned that was marked up.
Okay.
The front is the same, identical. You can't tell.
Okay.
Both identical, except when you open it up and then you look into it and you see the changes.
Okay. And the changes that are notated in State's 271, are they, do you recognize the handwriting?
I wasn't sure at first when I looked at it, but the more I looked at it, it appears to be Tex. I'm not a handwriting expert, but it appears to be Tex that had made some comments on it. I guess, yeah, that's my opinion.
All right. Let me ask you, can you tell the jury the notations that are made in handwriting? Where are the notations with respect on the inside of the will? Where are they?
Page 2.
And what do you see on page 2, if you could describe it?
There was a circle around wedding ring, and then there was a line, and then the word other jewelry ?
And in the 2006 will, that's already in the evidence, that is unmarked, can you, let me take a look at it real quick.
This is the marked one.
Okay, you hold on to the mark. So on page 2 of the unmarked will, at the top, C, lowercase c, close, open, close parens, my wedding ring I give, devise, and bequeath to Claude L. McIver III, and if Claude L. McIver III does not survive me, to the estate of Claude L. McIver. That's what it says in the unmarked will, right?
Yes.
Okay, in the marked will, what is circled?
The second and third words on the first line, wedding ring, circled.
And it says other jewelry?
Other jewelry ?
Okay. Any other changes to the second page?
Yes, there was the individual that I had mentioned that she had had a falling out with, Kathy Johansson, she had circled that $100,000 bequest to her, and it was just circled. Nothing else there.
Okay. And can you tell the jurors any other changes to this?
Not on that page. There, on the third page, there were circles around Devin Hugh. His last name was circled, and then there was a line up and it said not last name.
Okay. Any other changes?
No.
And I'm sorry, Judge, did I tender space 271?
You did not?
I'm sorry, I would tender space 271.
You got to change it too.
Any objection to 271? It's admitted.
Any other changes? I'm sorry. Did you find another one?
There was one other change, if you want me to, I don't know what exactly it meant, but
What page is it on?
page 4.
And if you could just describe what you see.
I just see where the whole paragraph, there was a marking in the words N-E-O-R-G.
Is it the top paragraph?
The paragraph E,
E, okay. This paragraph here.
yes.
Just a marking and it says, what?
N-E-O-R-G, period.
Can you tell the jury, you did not prepare Dinah McIver's 2006 will?
That's correct.
Okay. You actually provided the original copy of the original 2006 will to Mr. McIver?
Yes.
Did it have a blue back on it?
I don't recall. I don't think so. That blue back doesn't make it any more legal than non-blue back.
Okay. Did you know whether or not Dinah McIver had a safe at her Atlanta condo?
Not until after her death.
Okay. And can you tell the jury, did you have any conversations with Mr. McIver regarding the safe at the Atlanta condo?
I did. I believe there were some emails that went back and forth. There was some question as to whether she had any subsequent will that she had prepared after the 2006 will. And one of the possible locations that that will might have been kept would have been Diane's.
Your Honor, I'm just not sure I'm understanding the witness's answer. If he's giving us, if he's talking about things that Mr. McIver said or that other people said.
Okay. Of course, if you're not understanding, you'll have a chance to ask him questions. If you're concerned that we're straying into an area we shouldn't.
Yes, so hearsay.
Okay.
Okay. What you're relating to the jurors right now, is this based on your conversation and/or emails back and forth with the defendant?
Yes, the defendant mentioned the will, or the safes, excuse me.
Say that again.
The defendant mentioned that there were safes in the bedroom closet, I believe,
Okay.
at the condo.
Okay. And did I hear you say that you were talking to him about whether or not Dinah McIver had executed any subsequent wills?
I don't know that I talked to him about the subsequent will.
Okay.
But we had a conversation, emails about the safe.
Okay. And what were the subject of the emails regarding the safe? What were you talking about?
I asked him if I could be present when the safe was opened.
And can you tell the jury, do you know whether or not after you told the defendant you wanted to be present when the safe was open, do you know whether or not it was actually open?
Well, so objection to the extent that that answer may call for, or question may call for hearsay. I think the question would be,
Okay.
Mr. Rucker hears you.
I hear you.
All right, don't answer yet. I think Mr. Rucker's going to restructure the question.
Yeah, I am. Got a better question. Did you learn from the defendant whether or not the safe had been opened?
The defendant originally could not find the keys, could not locate the keys, and I suggested that a locksmith be called.
Okay. And then what happened?
The keys were found.
And so were you present when the safe was open?
At that point, it didn't make any, I didn't really have any interest in going over there. Terry Brown was taking some other documents to Tex, and he was there when it was opened.
Okay. Do you know if that was the first time the safe had been opened or not? Do you know?
I have no way of knowing when it was opened.
But after you suggested a locksmith to open the safe, keys were found.
Yes.
your knowledge, was a new will ever located within the inside of the safe?
No, not to my knowledge.
With respect to the will that we just talked about, which is States 271, the one you have in front of you, with the notations there in the margin about the wedding ring and the correction to Hugh's last name, do you see any notes or anything, I want you to look real good, indicating that Austin would get the ranch?
In this 2006 will,
Yeah, the one that has the notations in.
the changes, no. Austin's name was not mentioned in this will or in any writing.
Now, did you ever speak to the defendant about those notations that you thought perhaps he had made?
No,
Talk about
I
it.
have not talked to Tex.
Okay. Now, can you tell the jurors, when did you find out that something had happened to Diane?
It was a Monday morning. I was getting ready to go to work, probably 6:15, 6:30. I was shaving, and my wife came in and said, there's been an accident.
Yeah, hold on, I just don't want, Mr. Turner don't like you to say what somebody else says. Hearsay, right? It's not that they don't like it, it's just the law. It's the law, Mr. Harvey.
Both statements are true.
Yes. Yes, they are. It's law.
It's okay, Mr. Harvey. We just, no, we can't approach right now. Ladies and gentlemen, take a seat, and then we'll see if we still need to talk. Ladies and gentlemen, the law and the rules of evidence are what they are, and hearsay is something that either side can object to. It's not a defense attorney thing, or a prosecutor thing, or a judge thing. It is perfectly appropriate for either side to raise a well-founded objection to something that is inconsistent with the rules of evidence. It's not an effort by anyone to keep anything from you or from me or anyone else. It's an effort to keep both sides play by the rules. So it's not a defense or a prosecution thing. We've been working together long enough now in this trial that folks can joke back and forth. Mr. Rucker, I'm confident won't make that joke again, but I heard it as a joke. You should hear it as a joke. There's nothing inappropriate with either side raising an objection for hearsay or relevance or anything else that we've been working through during the course of this trial. Mr. Harvey, anything else?
Not at this time.
Okay. Mr. Rucker, back to your question, please.
Yes. After your wife said something to you that Monday morning, what did you do?
I proceeded to dress and go to the office.
And can you tell the jury on that Monday, which would have been September the 26th, did you see or speak to the defendant?
No.
Okay. How about Tuesday, September 27th?
Yes, I did on Tuesday.
Okay. And can you tell the jury how is it that you came to see or speak to the defendant on Tuesday, September 27th?
I felt that I had to go by condo and pay my respects. I had worked with Diane for 24 years and knew Tex and Diane for a long time. And I was still in shock too, but I wanted to pay my respects to Tex.
Okay. And can you tell the jury, do you remember about what time you would have arrived at the condo on that Tuesday?
I left the office about 5, and I don't recall the traffic that day. Getting to Buckhead, it can take 20 minutes or it can take an hour, as you all know. So I don't know what the traffic was that day, but I'm going to say between 5:30 and 6, probably. Right.
And can you tell the jurors, what did you see when you arrived at the condo that evening?
There were about probably 15, 20 people, maybe around. Some sitting on couches, some sitting in chairs. It's a large condo. There are two sides of the condo. They mainly were on one side. And Tex was on his cell phone.
When you saw him?
He's standing there again. Pardon me?
When you saw him?
Yes,
Okay.
that's correct.
Where within the condo was he when you first saw him?
I think he was there where everybody else was,
Okay.
in the main living room, I guess.
On which condo? The wine cellar condo side or?
The other living type where their bedroom was.
Okay. And when you went into the room, could you share with the jurors, what was the environment like?
Somewhat somber. I mean, it certainly wasn't a party atmosphere. It was somber. Some people were, I'm sure, crying, and everybody was very somber.
Okay. And when you saw the defendant, how would you characterize his demeanor when you saw him?
Well, he was on the phone, and I just saw his back at first. I couldn't tell. I didn't listen to who he was talking to or anything about the conversation.
Okay. So when you saw him on the cell phone and you saw his back, what did you do?
I waited until he got off the phone, and then I tapped him on the shoulder and said, "Tex, I'm so sorry." And I can't remember the way he grabbed my arm, or he said, "Let's go out in the lobby." And so I walked out there with him, and he made some comment to me. It was kind of a passing comment about to Diane's Social Security, and I didn't even think about that. I said, I have no idea. And then next thing I knew, we were in the lobby. There's an elevator lobby there where we take the elevators up.
Okay. So at the time, this passing comment, could you tell the jurors exactly what, and strike that, by the way, is this the first thing that he said to you when you saw him?
I think he said that when we were walking out. I mean, because when we got out in the hall, there was a totally different conversation. It wasn't, it changed.
Okay. And so
Out in the lobby.
the comment about Social Security took place while you were walking out.
That's my recollection. Is it was more of a passing comment. It wasn't. I know it wasn't out there in the lobby.
Okay. And by passing, what do you mean, a passing comment?
He just asked me a question.
Okay.
And just
Tell the jurors what question he asked you.
if I think, as I recall, if he could get Diane's Social Security, something like that, any benefits. And I said, I don't know, Tex. I just called the Social Security office.
Do you remember what he said specifically?
No, I don't remember.
Okay.
No.
I mean, if this is accurate. Can I get Diane's Social Security?
Something of that magnitude. I don't know if those were exact words.
I didn't put it in quotation. And what did you respond?
I don't know. You can call the Social Security office, something of that nature.
Okay. Can you tell the jurors what was his demeanor when he asked you that?
I really wasn't looking at him at that point in time, so we were just walking, so I don't know
Okay.
what his demeanor was at that point.
Okay. So did you actually make it out into the hallway, the lobby area there by the elevators?
We did finally, and I expected that at that point in time he would tell me how sorry he was and how it was a terrible, tragic accident, and say how much he loved Diane, but I never heard that.
Can you tell the jurors, was there anyone else that was out in that elevator lobby area when it was you and the defendant standing there at that time?
When we first went out into the elevator lobby, there was no one else there.
Okay. And so since you expected to hear that and you didn't hear that, can you tell the jurors, what did he say?
Tex next said that the firm was cutting him back, and he was only bringing in $10,000 to $12,000 a month. And the ranch was costing him $20,000 to $25,000 a month to maintain, and that they were going to restructure things by the end of the year.
Now, did he say anything else?
No, a woman came up that I think lived on that floor, an older lady named Rosalind, I think her name was. And she hugged him and said how sorry she was. And I felt very uncomfortable at that point. It was an opportunity for me to leave. I pushed the elevator button and left the building.
And from that day to this day, have you had any other conversations with the defendant? Other than what you've already testified to regarding the will?
Tex was invited to the Celebration of Life event that we had at the office for Diane, and I don't believe, I saw him there. I spoke with, I believe he was with his sister Dixie, who I had met previously. I did speak to her, but I don't recall speaking to Tex at that event, and I don't believe I've seen him, other than I saw him when I came in the hall this morning. He was out in the hall. Other than that, no.
And do you recall what date the Celebration of Life would have been at the office?
I don't have the exact date. It was in October, I believe, towards the end of October.
Now, I want to ask you about another area, and it has to do with Diane's 401k. Okay?
Okay.
Can you tell the jury, was there ever any conversation or exchange of emails or correspondence with the defendant regarding Diane's 401k?
Diane had a 401k at the company, as most companies provide, and Tex had inquired about obtaining the benefits, the proceeds from the 401k. I'm not the trustee under our plan, or the plan administrator, but I was able to get him in touch with that person, and he had to sign some documents to get the plan. He was a spouse. She, as I recall, her 401k plan did not name a specific beneficiary, but as a spouse, Tex would have been entitled to the benefits.
Let me just show you a couple of documents. They are marked as State's Exhibit 449 and 450. Can you tell the jury whether or not you recognize and can identify those?
The first one is an email. Well, it goes back, but at the top is February 27, 2018. It's from Angie Brooks. But the first one in this email, I assume this is an email chain that you're showing me.
Yes, sir.
It was from me to Angie, dated, or let's see, from Tex to me, dated November 16th, 2016. Copied Stan Smith, his estate attorney, and he was asking if we could locate, he was unable to locate the papers for Diane's retirement account at Guardian, and was asking our assistance.
Okay. That first email in the chain is on what date?
So before you start writing anything up, or we get into much more content, let's see if there's an objection to admitting.
I'm sorry.
That's okay.
Yep, I jumped the gun.
Unless, maybe we can do both together.
Yeah, I would tend to 449 and 450.
Well, I don't think we've heard anything about what 450 is. You may know what they are, and you may not have an objection, you may have an objection.
449, I don't have an objection to the one email in there that's from Mr. McIver, the November one. I object to the response, because I think the response after that doesn't go to Mr. McIver, it gets forwarded to somebody else. And then I do object to 450. I don't think Mr. McIver's on any of those. Or if he's on them, he's not writing.
Okay.
Okay.
449, Mr. McIver's email, no objection to. You're saying that rather than responding to Mr. McIver, whatever the next email is a response from someone to a third party, maybe saying, hey, what should we do with X?
Yeah, confirm.
Sure can.
And if that's the case,
Yes.
would agree.
Okay.
Right. Yeah. So I don't have an objection to admitting and publishing the first email. The second one is Ms. Brooks forwarding it to Mr. Rickert, Mr. McIver's copy. but it's not a statement of him, and I don't think it's necessary to shed light or add anything on to what Mr. McIver said.
Okay, and then 450, you looked at it again, and those are emails. Mr. McIver may have been on the distribution list, but they aren't things he wrote.
He's actually not on the distribution list
Okay.
for any of those.
So 449, there's no objection to the part of the exhibit that was authored by Mr. McIver. I'll allow that in. We just need to separate out the other part. And I don't know, 450, you'll need to come up with a different.
We've got different business. Until I have an opportunity to properly redact it, I'm just going to prevent the jurors from seeing the rest of the email chain.
Okay.
Is that all right? Okay. And I seek to publish to the jury State's Exhibit 449, the redacted, approved part of the email chain.
Go forth.
All right. So the first email is from Tex McIver to yourself, correct?
Yes,
On November the 16th, 2016.
yes.
And Stan Smith is copied, and Stan Smith is who?
Stan Smith is the estate attorney that Tex used and prepared the 2006 will.
Okay. And the subject, Angie, do you know what that is in regards to?
That refers to Angie Brooks.
And who is she?
She is the executive vice president over at Corey Companies, U.S. Enterprises.
Would she be the person who would be responsible for kind of keeping up with the company's 401k plans for the employees?
Yes, at the time, she was the, I guess, administrator, whatever they call it, of the plan. She was the person that interacted with Guardian.
Okay. And can you share for the jurors by reading this email exactly what the defendant said to you?
It's a little blurry, but you can.
Would you do better if I just handed it to you?
I would.
Remember to read slowly. The way you did that one paragraph was great.
All right, you got it down now.
Okay.
You want me to read it from the beginning, Mr. Rucker?
Yes. For completeness.
Ken, although I am sure it is my error, we are unable to locate the papers needed to identify Diane's retirement account at Guardian and any other administrator. Would you very much mind asking her to resend to us with a proper authorization for us to access the accounts? ? They have flatly refused to furnish us information indicating that Angie is the only individual to free them up to do so. Also, one of our representatives needs to meet with her to take over the payrolling of Javier Hernandez, the manager at our ranch. We anticipate such a meeting will be short once it is understood which payroll system she uses. Her IRS quarterly filings, copies of payroll activity for this calendar year, and the status of affairs such as the repayment of loans, etc.
And I've got one more quick area to discuss with you, and then I'm done. Are you familiar with guns?
Somewhat. I wouldn't consider myself a gun freak or anything like that, that's for sure, but I do have some guns.
Okay. And can you share with the jury what kind of guns do you have?
My father was an avid hunter, so I have some of his old deer rifle, shotgun, .22. I have a couple of revolvers that I've used personal defense, and I have a semi-automatic that is in its case now. I don't use that anymore.
Okay. And the revolvers that you have, what caliber are they?
38.
Okay. And the semi-automatic that you have, what caliber is it?
You know, a 30 caliber or something like that. I'm not sure exactly what the caliber is. It's a Sig Sauer P238 is the model number.
Okay. And I want to ask you about whether or not you have ever unintentionally discharged your semi-automatic handgun.
I did. I had a couple of years ago. I'm not as familiar with semi-automatics as I've always had revolvers, and totally different animals. I was had shot it at the range. I purchased it and was cleaning it. I had come back from Augusta, a long trip. I was tired. I don't even know why I was doing it, but I pulled the slide back, had it down. It was in my office downstairs in my basement. Pulled the slide on it back. My finger obviously was inside the trigger parameter, whatever they call it. But I hit the trigger and it discharged, went into my desk, and that was it. I was embarrassed. It was not something you like to have. I call it a negligent discharge. It was my fault. But you learn, and I put the gun away, and I won't pick it up again until I really am familiar with semi-automatics. I'll stick with my revolvers.
And when you pull the trigger on your semi-automatic, does it take the same amount of force as it does when you pull the trigger on your .38 revolvers?
No, they're totally different. Totally different. Semi-automatic is a great gun to shoot, but it's got much less trigger pull.
Okay, I would do some noise. I couldn't hear.
The semi-automatic is a great shooting gun. I prefer to shoot it over a pistol, a revolver, but the trigger pull is much different. On the revolver is much more trigger pull. I don't know what the exact pounds are.
Does it take more or less force on the revolver than the semi-automatic?
It takes more force on a revolver to pull the trigger.
And in your discharge, you can say to the jurors that the gun went off when you hit the trigger.
The gun wouldn't have gone off if I hadn't hit the trigger. Yes. I mean, it was an accident on my part, a mistake on my part. Put that way.
Can you tell the jurors what kind of sound did it make?
Loud.
And as a result, was anyone injured?
No, there was nobody around. I mean, it was pointed down. I would never point it loaded, or well, I thought it was unloaded. I didn't realize the round was in chamber. I had the clip out. But even at that, I never point a gun at anyone, even if I think it's unloaded, I know it's unloaded. You don't point a gun at someone, you always point it down. I was holding it down like this.
And can all you guys see that?
Pardon?
I just want to make sure they can see that.
Yeah, I had it down. I was down, pulled the slide back. My finger must have obviously hit the trigger, went down into the desk.
And you said you didn't realize that there was actually a bullet in the chamber.
I didn't. That was my not being as familiar with semi-automatics as I should have been.
Okay.
Been a long time since I had fired one.
Okay. And can you tell the jury, did the loud sound affect your ears in any way?
I had some slight hearing loss in my left ear. I mean, I don't wear any hearing aids or anything, but I did have a little bit of a slight hearing loss in my left ear.
Okay.
The back blast came back.
And can you tell the jury, did this experience, did it occur before or after the death of Dinah McIver?
Before.
And can you tell the jury, do you have an approximate time frame for it, when it would have occurred?
2 or 3 years ago.
And can you say to the jury, did you share this incident, what happened, what you did with Dinah McIver? Did you tell her about it?
I told her, you know, we had lunch every day practically, all of us in her office, and one day at lunch I think I told her, and she laughed. Of course she laughed, and she that was typical of Diane. She would get a kick out of that.
Okay.
So she was.
Okay. Now let me ask you this: do you know Danny Jo Carter?
Yes, I met her.
And did you ever tell this story about discharging your firearm in your home? Did you ever tell that story to Danny Jo Carter?
No, I know Janet Jo Carter. I rarely see her, but I would never. No.
But you never told her that story, correct?
No, mentioned it to Diane.
Okay. All right. I believe that's all my questions. Thank you very much, Mr. Rickert.
Okay. I think we'll take our morning break, unless you want to get started before we take our morning break.
I was going to ask if we could take our morning break.
All right, granted. Ladies and gentlemen, we don't have a set, this meeting I had to go to at lunch got canceled, so we don't have a set lunch time. We'll see how things flow with cross-exam and whoever the next witness might be. But we'll take our morning break now. We'll try to keep it to about 10 minutes. I'll have Deputy Murphy check on you guys in a few minutes and see when we can get you back in here. We'll talk about the case while you're back there in your space. And I trust that you are letting Deputy Murphy or Ms. Hansberry know if there are any issues back there, no toilet paper, it's too hot, too cold, anything like that, because we'll do what we can to address it. Thank you.
All rise for the jurors.
Judge, I spoke to Ms. Clark Palmer. I neglected to tender an exhibit. It's a security deed that is associated with the 2011 promissory note.
Okay.
And it states exhibit 452. And if the court would allow me just to reopen, correct, just to tender it.
Okay, we'll do that. We'll get on the record once the jury comes out.
We ready?
Great. Please.
All jurors are present in the counter for you, Your Honor.
Thank you, Deputy Murphy. Welcome back. You're welcome to be seated. Mr. Rucker, it's my understanding you had one other exhibit that you meant to tender before you sat down, figured that out during the break, and you'd like to do that now before Ms. Clark Palmer, or so. 2 cents each, before she takes over.
Yes, sir. Your Honor, at this time, I'd like to tender states 452. It's the actual security deed that is associated with the December 2011 promissory note, which is States Exhibit 428. So 452 goes with 428.
428. Any objection to that, Ms. Clark Palmer?
No, Your Honor.
It's admitted. Thank you, Mr. Rucker. Ms. Clark Palmer, your witness.
And good morning, Mr. Rickert.
Good morning.
I want to ask you a question about one of the last things you told us about and then kind of go backwards and start from the beginning. You told the jury about this comment that Mr. McIver made to you. This was the Tuesday, you think, after Diane died? Is that your memory?
Which comment are you talking about?
The comment about the
Oh, yes.
needing to restructure the finances.
When I went to visit him at his condo.
Okay, and he told you that at that point in time, his income was about $10,000 a month, right?
He mentioned $10,000 to $12,000 a month. I don't know whether that was after tax, pre-tax, but
That's
I
what he
just
said.
remember a comment like that.
Okay, and he said that the ranch was costing him about $20,000 to $25,000 a month.
Yes,
Okay, and $10,000 is less than $20,000 or $25,000, right?
yes,
Okay.
obviously.
All right, so just by math, it seems like he would need some more income to keep up with those expenses on the ranch, correct?
Yes, that's a reasonable assumption. I would agree with that, yes.
And you knew Diane was being paid for her work at U.S. Enterprises, correct?
Of course.
Okay, so her salary may help make up the difference between his income and what the ranch was costing, correct?
I don't
Just
believe,
stop for a second.
Yeah. I don't think Mr. Rickert, I think this is speculation.
Well, the question was may cover, so I'll sustain. If he knows how it's working, you can ask him if he knows how they spent their money. But I didn't ask that, so back to you.
Okay.
I'm sustaining the objection as to his speculation as to how the money was spent.
My question is, okay, so my question is not, do you know if Diane was contributing to, well, let me ask that question first. Do you know, was Diane giving money, contributing money to the ranch expenses?
my understanding was no, she was not. The condo was Diane's responsibility. She paid for the condo, Tex paid for the ranch. They kept everything separate. All of their finances were always separate.
Okay,
And so Tex was responsible for the ranch, she was responsible for the condo.
okay, so, all right, fair enough. But he needed additional income from somewhere to bridge that gap from 10 to 20, right?
I would, yes, I certainly would think so.
Okay. So let me go back and start with the promissory note, states 427 that we looked at. This is the document you said that you prepared?
Yes, I believe I did. Mhm.
Okay. This promissory note is a little bit different from a note secured by real estate in that the promissory note is not secured by a piece of property, right?
I believe that when we did this, this was just a simple promissory note. We did not have a security deed. That's correct.
Okay, so when you say simple promissory note, can you tell the jury what you mean? Just kind of like a one or two sentence?
It evidences a debt. It's not secured by any personal or real property.
So if somebody doesn't pay on a promissory note, the person who loaned the money, what can they do if they want to go get that money back?
File suit against the individual.
Okay? They can't go, well, with this particular promissory note, this note didn't give Diane Smith any rights to go foreclose on the ranch property through this note, right?
That's correct.
If Tex didn't pay on this note, she would have to file a lawsuit.
That's correct.
Okay. And work that out in court. I mean, that's where, when you file a lawsuit, you file it with the court.
Work it out in court or amongst yourselves.
Okay. And this note is dated March 1st, 2005, correct?
Yes.
And it's in the name of Diane Smith, correct?
It's prior to her marriage. That's
Okay.
correct.
Yes, so that was my next question, is before they got married, right?
Yes.
Okay. And Diane never filed any kind of lawsuit against Tex related to this promissory note, correct? That you know of.
Nothing that I know of, I never heard her speak about any lawsuit.
Okay. And during this time, you were giving her legal advice, right?
From time to time in her personal affairs, yes.
All right. Then Tex and Diane get married, right? After March 1st, 2005.
That's correct.
They get married in November 2005?
Yes.
And after they get married, or around the time they get married, there is a change to the deed to the ranch, correct?
Just as my recollection, I believe it was just after they got married, then they changed the ownership structure, yes.
Prior to the marriage, Tex was the, if you know, was the sole owner. He was the only person named on the deed for the ranch.
That's correct.
Okay. After they get married, the deed, Tex had to change the deed. If he was the sole owner before, he had to change the deed, correct?
Yes.
Okay. And he changes it to that they own it as joint tenants with rights of survivorship.
Very good. That's correct.
Thank you. All right. And by doing that, he and Diane own the ranch together,
Yes, jointly.
jointly. And if one of them dies before the other, the person who is surviving, the surviving spouse becomes the sole owner of that property.
Yes.
All right. All right. So then I'm going to jump forward to December 2014. No, I've gone too far. Sorry. December 23rd, 2011. This is states 428. Okay. Now this note is secured by property, right?
Yes.
Okay. So this note, unlike the promissory note, this note says essentially the ranch is pledged as collateral. Is that the right way to say it? Is pledged against this $350,000 loan?
She would have, she had a $350,000 security interest in the ranch.
All right. And this loan required Mr. McIver to make interest payments, correct?
Interest only, yes.
Okay. And with this loan, It's due December 23rd, 2014, right?
That's correct.
And on this loan, if Mr. McIver doesn't pay that, the balance on December 23rd, 2014, now Diane has some rights available to her with regards to the ranch and things that she can do to the ranch, correct?
She could, if she had chosen so.
Okay.
Yes.
She could have foreclosed on the ranch if she wanted to, right?
She had that ability to do that. I believe this was a second security deed, but I think there was another loan that Tex had was prior to this deed, but
Okay.
yes.
And foreclosure is a little bit of a process to foreclose on a piece of property, right?
I'm not a real estate attorney. I've never foreclosed on a piece of property, but it's my understanding in talking to and knowing about the...
Stop. Yeah. Object.
I can't.
It's just really outside.
He said as much, so next question.
But even not being a real estate lawyer, you know that it's not like Diane just stands up and says, well, on December 24th, 2014, I'm now the sole owner of this property because I foreclose on it. That's not how it works, right?
Some objection, Judge.
Okay, I'll allow that question.
That's not how it works.
Okay. You don't know what all the steps are.
I don't.
All right, fair enough. And Diane never asked you to take any steps to foreclose on the ranch, correct?
Correct?
Okay. Diane never told you she wanted to foreclose on the ranch, correct?
That's correct.
Okay. What she did do, right before this loan is due, is executed States 429, the renewal promissory note, correct?
Yes.
Okay. And did you say that the interest rate is lower in the renewal promissory note?
As my recollection, I think it was about 5% on the first one, and I think she dropped it to 4.5%.
Right, okay, so on States 428, the interest rate is 5.25%.
Yeah, 5.25.
And then,
She dropped it down to 4.5.
okay, and that was her prerogative to do that, correct?
Absolutely.
All right. And after she asked you to prepare the renewal promissory note, at no time after that, after 2014, did she ask you to do anything with regards to foreclosing on the ranch, right?
Correct.
And she never told you she wanted to foreclose on the ranch after 2014, correct?
No, that's
No.
correct. That's correct.
Okay. All right, so let me move on. Oh, you told us that, you were asked about the renewal promissory note, and I think you said something about Mr. McIver he couldn't pay the $350,000. I think that's what your testimony was on direct. Here's my question. Do you know if Mr. McIver couldn't pay the $350,000, or if just for some reason he wasn't going to pay it in December of 2014?
All I know is that Diane asked me to prepare a renewal promissory note with a different interest rate.
Okay. You don't know the status of Mr. McIver's finances in December of 2014?
I don't.
Okay. You don't know if he had the ability to pay the $350,000?
I don't. You're correct.
You just know that Diane asked you to renew the promissory note and extend the due date?
Yes, that's correct.
All right. All right, so we talked about the States 447, which was the codicil to Ms. McIver's will. And you told us that this was a document that you prepared, right?
Yes,
Presumably you prepared this with her input, right?
of course.
You didn't just,
No, I didn't
Make up-
just decide to revise the will on my own.
right, okay. But for whatever reason, she never executed it, correct?
That's correct.
Okay. That was her prerogative to decide to execute a codicil or not execute it, correct?
That's correct.
You couldn't force her or make her execute that codicil if she didn't want to.
It's very hard to force Diane to do anything she didn't want to do.
Okay.
She was a strong person.
Okay. So let me move on to States 441, which is the 2006 will. So the first thing item 1 says is that Diane wants to be cremated, correct?
Yes.
All right. Did you understand from Mr. McIver after Diane died that he was trying to find out if she wanted to be cremated or buried?
No, I don't recall that. I don't know.
Okay.
I don't remember.
But anybody who reads this will would understand Diane wants to be cremated.
Yes.
Well, maybe I shouldn't ask anybody. You read this will and understand it says she wants to be cremated, correct?
That's correct.
Okay. And wills are documents that are meant to be, the things that are set out in somebody's will are things that are meant to be honored and followed, correct?
Yes, that's my understanding, of course.
These aren't guidelines for the executor, and then the executor is free to do whatever they want with somebody's estate, correct?
Yes, that's correct.
Okay. All right, so let me move down to item 3. All right, item 3 says, in English, I think if this is a fair summary, that she wants her interest in the farm to go to Tex. Correct?
Yes, that's correct.
She also wants the furniture, the art, and the furnishings, the livestock, equipment, and other personality to go to Tex.
Correct.
Okay. All right. But at this time, actually, at all times between 2006 and when she died in 2016, the ranch was always owned as joint tenants with rights of survivorship, correct?
Yes.
So in fact, her ownership interest in the ranch never becomes part of her estate at all, right? Because when she dies, it goes to Tex. Doesn't have to go through probate, doesn't have to go through her estate.
There's a caveat in Georgia law to the Slayer statute that
I'm
may
not talking about
include
that. That's not what I'm asking about.
That is,
He's answering your question, so you can finish answering the question.
Well, I would object to the area he's
Objecting to your
about.
witness's answer.
Yes, I am. I'm objecting to.
So why don't you ask your question again?
When you own a piece of property as joint tenants of rights of survivorship, it's a non-probate asset, correct?
It does, the ownership transfers by operation of law outside of the probate court.
Okay.
That's correct.
And outside of the probate court means that whatever you write down in your will really doesn't matter, because by operation of law, your ownership in the property is going to that other joint tenant, correct?
Again, with that caveat about the very narrow provisions under the Slayer statute that might preclude that
Okay.
from happening.
Okay. Other than that, she could have written.
Other than that, yes,
Okay.
it would transfer.
Okay. Now, separately, the furniture, the art, and the furnishings, that's something different. She's free to leave that to whoever she wants to,
Yes.
if it's her property, right?
Correct.
Okay. All right, then item 3B, in her will, she leaves the furniture, art, and furnishing at the condos to her husband, correct?
Yes.
All right, and then she leaves her wedding ring to her husband, correct?
Yes.
And any interest she has in DRS investments, she leaves to her husband, right? And if he's not alive, she leaves it to Richard Harrell.
Yes,
And then she lays out some specific dollar amounts that she's going to people, correct?
yes,
Okay. And then she says, item 4, I think we're up to, that she's got some other personal property that says she's left a list with her personal effects about where she'd like that personal property to go. Right?
yes, there was a list. It was not mandatory, but
Okay. Then item 5, she leaves a life estate in her condos to her husband, Tex McIver, Claude L. McIver III, right?
correct?
She doesn't, in her will, she doesn't say, you have my condos and you're free to do whatever you want with them, right? That's not what it says.
That's right.
A life estate means that he's allowed to live there while he is alive, right?
Yes.
And then after he passes away, does the condos goes back to her estate? Is that how it works? Do you know?
The state or the trust, whichever was in effect would be at the time. That's my understanding, yes.
Okay. But Mr. McIver is not free to sell the condominiums if he has a life estate, correct?
No, he could not sell the condominium.
And he's not free to transfer the ownership to somebody else if he has a life estate, correct?
I don't know. I'm not going to answer that because I can't say that he couldn't lease. I believe he could lease that out or transfer, have some other interest. I'm not sure. I'm not.
Okay, fair enough. And then item 6 says, the remainder of my property, I want it to go into a trust.
Yes.
Okay, and you're the trustee, you told us, right?
Yes.
Okay, and then it lays out some terms of what the trust is going to do, correct?
It provides for the, yes.
Okay.
Yes.
And some part of this trust is going to go to the benefit of her husband, right?
Yes.
Talks about paying for his medical and health care to the extent that he's unable to pay for it.
Yes.
Okay. And then we see where she talks about in her will providing for the post-high school education of Tiffany Hugh and Devin Hugh, right?
Yes.
And this will is, this document is 19 pages long. It's numbered up to page 18, and then there's a
That's a station clause.
attestation clause that goes with it, correct?
Yes.
And then there's 2 other pieces of paper.
Yes.
But the typed document, the typed last will and testament of Diane McIver is 19 pages long. With the attestation clause.
That's correct.
All right, thank you. I missed one thing in the will. And back in item 1. Okay. Item 1 says not only that she wants to be cremated, but it says the cost of the cremation should be paid out of my estate.
Yeah, it's very common.
Okay, that's typical?
Yes, it is.
All right. And you told us about some communications and a meeting that you had with Harold Hudson, right?
The meeting, the face-to-face meeting we had?
Yes.
Yes.
There was one face-to-face meeting, and then there were some other emails, right?
That's my recollection. Again, it was 8, 9, 10 years ago. But yes, I think we had one meeting and we had some emails that I was copied on or something.
Okay. And was there any other lawyer that you were involved in having discussions with who was preparing changes or a new will for Diane McIver?
No, the only individuals that I've ever dealt with Diane on wills have been Stan Smith, who prepared the 2006 will, and Harold Hudson, who we met with. But there was never a will that was signed.
right, you jumped ahead to my next question. You never saw a will subsequent to the 2006 will that Diane signed and executed?
I have not seen an executed new will.
Okay.
Now, that doesn't mean she didn't have one, but I haven't seen it.
Well, you say it doesn't mean she didn't have one, but from 2006 until she died in 2016, she was coming to you for legal advice on some matters, right?
Yes,
And you had been involved in conversations with Harold Hudson, correct?
correct.
And you actually prepared a codicil, the 2007 codicil to her will, correct?
Yes, that was a long time right after they were, Austin was born, I believe.
Okay. So in those communications and in all those years from 2006 to 2016, you never saw an email with a signed will attached. You never saw a printed document that Diane gave you where it was a new will that she had signed and executed, correct?
That's correct. The only thing during that period of time, Diane and I were at lunch one day having lunch, and she did mention, I need to, and it was a couple of years before she
Well,
passed
let
away.
me just
Okay, all right.
ask you to respond to
All
my
right.
question
You
without
got it.
telling
You
me
got
what
it.
Mrs.
You got
McIver
it.
said. Did you ever
No.
see an email, or did she hand you a document where she had signed and executed a will
She did not. No, she
subsequent to
didn't.
2006?
No, she didn't.
Okay. And you told us about after she died, you went into her office and you were part of going through the locked file cabinets that were in her office, correct?
I found the will file when Tex had asked me to wanted a copy, yes.
And Angie Brooks was there too?
I don't recall on that day that Angie was there. When Tex wanted all of her files about a month later, Mr. Corey, Angie, and I went through the files and we boxed everything up for him. They had made a request that all of the files be given to him, not just files, but personal effects. And so we took the personal effects from our office, and of course, as you've gone through death, that's painful for us, having to kind of clean out her office. But we went through the files. We wanted to separate any business documents and make sure that they were not included, because she did have some business material in those filing cabinets also. We boxed them up for Mr. McIver to pick up.
Well, on the day the locksmith came, who was there when the locksmith drilled open the lock cabinets?
I don't recall myself, maybe Angie Brooks, I don't know who was actually there that day.
Okay. But when you went through those file cabinets, you didn't see a signed, executed will that was subsequent to the 2006 one?
No.
Okay. You were involved in you had some involvement continuing after Diane died with her estate, correct?
I dealt with Tex and his attorneys on some aspects of the estate, that's correct.
Okay. And after Diane died, U.S. Enterprises made a demand against her estate, correct?
That's correct.
U.S. Enterprises made a demand for a debt that was owed from Diane to U.S. Enterprises, right?
Yes.
And the amount was $975,000, correct?
Yes.
Okay. And Diane had one life insurance policy where if she died, $1 million would be paid out upon her death. You know about that policy, correct?
That was in connection with a company that she was part owner in DRS Investments.
Right. That policy, that $1 million policy, Mr. McIver is not a beneficiary under that policy, correct?
Only to the extent that he became half owner in DRS Investments.
And ultimately, the money from that policy did not go to Mr. McIver, correct?
That's correct.
And ultimately, the money from that policy did not go into Diane McIver's estate, correct?
That's correct.
Okay. And we also talked a little bit about Clay Management Company, which you know is a company that Diane owned, correct?
That's correct.
And Clay Management Company owned some billboards, right?
Ground leases, yes, they had some ground leases.
Okay, so explain, tell the jury what ground leases are in a couple sentences.
Ground lease is the company would own the real estate upon which the billboard is located. They may not own the structure itself, but they would at least have the real estate. They would then lease generally the structure to another company. You've seen the big companies, Lamar, Clear Channel, around, and a lot of times they don't actually own the real estate. They lease the real estate and build their sign on that real estate.
So in this case, Clay Management owned a piece of property, right? Or more than one piece of property, correct?
Yes,
And then also had contracts with some companies that did billboard advertising, where those companies said, hey, let us rent your land, we're going to put a billboard up and we're going to advertise on it, right?
that's correct. They were called ground leases.
Okay. And so the billboard companies were paying Clay Management for the right to lease that property.
Yes,
Okay. And after Diane died, the property, the ground leases owned by Clay Management Company did not go to Mr. McIver, correct? Ultimately,
ultimately they did not.
okay? And ultimately, they were transferred out of her estate, correct?
Yes,
Okay. So you also told us in your direct testimony about this email from November 2016 where Mr. McIver is asking you about the 401k policy. You remember that? It states 449.
I do.
Okay. And you said, I think I heard you say that Mr. McIver was not the beneficiary on this 401k policy?
He was not the named beneficiary. She had neglected, to the best of my recollection, she neglected to name a beneficiary under that 401k.
And that means that the 401k then goes to her estate.
We go to her spouse.
Is that what the plan documents say?
I have not seen the plan documents. That's what we were told by our guardian.
Gotcha, okay. All right, thank you. Just have a moment. I think those are all my questions, Judge.
Any redirect, Mr. Rucker?
Oh, I'm so sorry. I'm sorry. I forgot one last thing. I forgot to ask, at the time that you talked to Mr. McIver, back this conversation in the Tuesday after Diane died, at that point in time, you don't know if he was taking any medication, correct?
I have no idea.
Don't know if he was taking Xanax, right?
Doesn't know if he was taking any medication.
I have
No idea. Mr. Rucker, any questions?
Ms. Clark Palmer asked you about State's Exhibit number 427. This is the promissory note for $750,000. Can you tell the jurors, do you know what that $750,000 loan to Mr. McIver was used for?
I don't know.
Okay. And do you know whether or not the added structures to the ranch were done before the November 2005 wedding?
Yes, they were. Diane put a tremendous amount of money into the ranch prior to their marriage.
Okay. Ms. Clark Palmer asked you that in Diane McIver's 2006 will, it states that she wanted Mr. McIver to get the ranch and the furniture and everything. She lists a lot of things. Is that correct?
Yes.
And that will was executed before Austin was born, right?
Yes, it was. My understanding is Austin was born after the will. I don't know the exact date, though.
Okay. She also asked you, about whether or not you ever saw a new will. But in your conversations with the defendant about gaining access to the safe in the Atlanta condo, who did you send to go and look at the safe?
Terry Brown.
And can you tell the jurors, in relationship to when you had the conversation with Mr. McIver where you said, hey, I'm going to call a locksmith, how many days passed before Mr. Brown actually made it over there to look into the safe?
The next day, maybe 2 days at most.
And in between that time, is that when he told you, hey, I found the key?
Yes.
Now, Dinah McIver in her will wished to be cremated, and she said, hey, you can pay for my cremation out of my estate. Ms. Clark-Palmer asked you that, remember?
Yes.
Okay, and that's true, right?
It directed the estate to pay the cost of the cremation.
Right. And can you tell the jury, do you know whether or not the estate would reimburse the person who actually paid for the cremains?
Of course they would. I don't see any reason why they wouldn't.
Right.
It's a legitimate estate cost. They would reimburse anybody.
Right. Ms. Clark-Palmer also asked you about the clause in Dinah McIver's 2006 will that says she wanted her wedding ring upon her death to go to her husband. Is that correct?
Yes, it is.
And upon his death, it would go into his estate. Is that right?
On her wedding ring?
Yes.
If he still owned it.
If he still owned it.
If it was to go to, he could have done anything he wanted with the ring after he got it.
Okay. And let me show you. And you knew Robbie to be who in relationship to the defendant?
Did you say Robbie?
Robbie.
Robbie was Tex's son. I believe it was his youngest son.
Okay. And so let me show you an email. It's already been admitted into evidence. It states 147:20. Are you familiar with a meeting that would have been had with Harold Hudson, Tex McIver, and Dinah McIver talking about some changes or things that she would like to see have done to her new will?
Unless I was copied on that, I don't think Diane ever showed me that. It doesn't look familiar.
Okay. But here in this exhibit, which states 147:20, do you see where it says, why does Robbie get my wedding ring upon my death?
She was very concerned that she didn't want Robbie.
Sorry,
Stop.
objection. Non-responsive. The question was, is this what the Senate says?
If it's non-responsive, then we may be getting into hearsay.
I understand. But that's what it says, correct?
Why does Robbie get my ring upon my death? That's what it says.
Right. And can you share with the jurors if Ms. McIver died and left the wedding ring to her husband, and he died, it would go into his estate, right?
If it was still in his possession, it would.
And in that regard, would it be possible for Robbie to actually get it?
If he was a beneficiary under the will, yes.
Can you tell the jurors, what is the slave statute?
Objection, Your Honor. Relevancy.
Overruled. Tell me what the slave statute is.
Well, I'll preface this, but I'm not a trust in the state's attorney, but in my reading of the Slayer statute, if someone cannot profit from the death of a spouse that they were responsible for. They were responsible for the death. They would be precluded from inheriting anything.
And that's just your understanding of it?
I haven't looked at that statute in a year or two.
Okay. Okay. And can you explain to the jurors something you said in response to Ms. Palmer's question? You said it's hard to force Diane to do something she did not want to do. Could you explain that? Why did you say that?
Diane was very strong-willed, very forceful. If Diane didn't want to do it, she wouldn't do it. She was her own individual.
And in response to Ms. Clark Palmer, you knew Diane and Claude McIver to keep their finances separate.
Yes, Diane always filed separate tax returns. They didn't file joint tax returns. They always filed separate returns.
And she was responsible for the Atlanta condo and all the expenses associated with it.
Yes.
And her husband was responsible for the ranch and all the expenses associated with it.
Yes.
Thank you very much. That's all my questions.
Any questions from the jurors? Too late. Mr. Rickert, do you know if the $750,000 promissory note, first of the three notes you talked about, was paid in full, or if there was still some outstanding balance at the time of Ms. McIver's death?
I don't know that. Diane, I did not keep up with her notes, so I have no idea whether it was paid or forgiven or what happened.
You were asked about the demand that U.S. Enterprises made against Ms. McIver's estate, $975,000, I think you said. Can you tell the jury more what the basis was for that?
There was some money that Diane had owed to one of her companies, and that was assigned to U.S. Enterprises. U.S. Enterprises filed the estate claim against the estate.
You say it was assigned to U.S. Enterprises. U.S. Enterprises somehow acquired the right to collect that sum.
That sum from DRS Investments, one of her companies.
Okay. And so the proceeds from that $1 million insurance policy
Went to U.S. Enterprises.
Okay. When you were talking about the filing cabinets in Ms. McIver's office that were locked, but maybe you had a key to one of the drawers, did you say that a locksmith was already coming, or you called a locksmith because you could only unlock one?
We called the locksmith because we couldn't find either one of the keys at first. After we called the locksmith and they were on the way, we did find one key to the one cabinet, but he still had to get into the other cabinet.
Mr. Rickert, any follow-up with Mr. Rickert concerning any of that?
No, sir.
Ms. Clark Palmer?
No, thank you.
All right. Thank you, sir, for your time.
Thank you.
Mr. Rickert, next witness.
Yes, sir. Will be handled by
Ms. Griffin.
The state calls Mary Radford.
Ms. Clark Palmer, will you be handling Ms. Radford?
Yes.
I just want to get on the record that the concerns that you've raised before are preserved in connection with this witness. You're free to renew them as you see fit. They're certainly preserved. We got it.
Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. If you will, have a seat for us, please. Get as close to the mic as you can. For the purposes of the court's record, please state and spell your name.
Okay, my name is Mary Radford, MaryRadford.
Ms. Radford, before we get started, I'm Judge McBurney.
Hi, Judge McBurney.
Nice to meet you. You brought a bunch of documents up with you, which is
Yes.
fine. Could you turn them face down?
Sure.
And if for any reason you need to refer to them, make sure you're alerting the lawyers so they can be aware of what it is you're looking at. So I'm not saying don't ever look at them, but if you need to, let's make sure that that's being disclosed to everyone, because I can't see the way this courtroom is set up, what all is going on down there, okay?
Okay, great, I'd be happy to.
Great.
Did you know that getting legal help can make all
You may need legal help. You have dialed the right number. All right, that's great.
All right, good afternoon.
Good afternoon.
Could you please introduce yourself to me again, please, by stating your name?
Yes, my name is Mary Radford.
And where are you currently employed?
I'm employed at the Georgia State University College of Law.
And what do you do for Georgia State University College?
I'm a law professor. I'm the Marjorie Fine Knowles Professor of Fiduciary Law at the law school.
And how long have you been a professor at Georgia State University College of Law?
I joined the faculty in 1984. I took a couple of years where I took leaves, but it's pretty much been where I've been since 1984.
Okay. And what classes do you teach at Georgia State University?
I teach the basic wills, trusts, and estates class, and I teach a seminar in estate planning, and I teach law in the elderly.
Okay. Could you please give us a little bit of information about your background and education?
Sure. I did my undergraduate work at Sophie Newcomb College at Tulane University. And, pardon me?
Say it again.
Sure. My undergraduate work at Sophie Newcomb is SOPHIE NEWCOMB College of Tulane, TULANE University. I had a degree in French and philosophy. And then I taught high school for 4 years in Atlanta and decided to go to law school. So I went to Emory Law School, graduated from there in 1981. And I joined a law firm that was then called Hansel and Post. That's HANSELL and Post. I stayed there for 3 years, and then in 1984 I joined the Georgia State faculty.
Okay. And do you have any publications, books, or articles?
I do. I have 3 treatises on Georgia law, one on Georgia wills law, one on Georgia trust law, one on Georgia guardianship law. I've written a volume of another multi-volume treatise on national trust law, and I'm co-author of a little book called Uniform Trust Code in a Nutshell, which is used by law students sometimes, maybe as a crutch to help them understand the courses. And then I've written about probably 50 articles that have been published on wills and trust law.
And you said you have 3 treatises.
That's correct.
And I'm going to show you these 3 of them. If you could show each one and tell which one each one is to.
Okay. This is the treatise on Georgia trust law called Georgia Trusts and Trustees. This is the one on Georgia wills law called Wills and Administration in Georgia. And this is the one on Georgia guardianship law called Georgia Guardianship and Conservatorship.
And what are the dates of publication for your treatises?
Well, for each of them, I do an edition every year, so these are all of the latest edition, which is the 2016-2017 edition.
And could you please describe any awards and accolades you have earned?
Yes, I was awarded the, I believe it's called the Treat Award for Excellence by the National College of Probate Judges back in 2002. And then the section of the State Bar of Georgia called the Fiduciary Law section, which deals with wills and trusts, gave me the Verner Chafin Career Service Award in 2009.
I'm sorry, what was the name of that award?
Sure. The last one? Yeah. Verner, V-E-R-N-E-R, Chafin, C-H-A-F-F-I-N, Career Service Award.
And do you belong to any professional legal organization?
I do. I belong to the American College of Trust and Estate Counsel, which is called ACTEC. I served as their president a few years ago. I'm an academic fellow in the college. I'm a member of the National Academy of Elder Law Attorneys, and I'm a member of the American Law Institute.
And have you ever participated in any efforts to reform Georgia law related to probate, wills, trusts, and estates?
I have. I was very privileged to serve as the reporter for 3 committees. The first one drafted what became the Georgia Probate Code of 1998, which is the code that deals primarily with wills. And the second one drafted the Georgia Guardianship Code of 2005. And the third one drafted the Georgia Trust Code of 2010.
And have you ever testified before in the courts of Georgia as an expert in the field of wills, trusts, and estates?
I have. I've testified at the DeKalb County Probate Court, the Fulton County Probate Court, the Fulton County Business Court, Fulton County Superior Court, and Gwinnett County and Cobb County Probate Courts.
Okay. And do you know about how many times that was that you've testified?
That would have been over a long period of time. So I would say testified probably 6 to 8 times, yes. I've served as someone who was going to be called in cases several times, but then the cases have often settled.
Okay. And Your Honor, at this time, we'd like to tender Ms. Mary Radford as an expert in the field of wills, trusts, and estates.
Okay. Professor Radford, you are qualified for the purposes of this trial as an expert witness in the field of wills, trusts, and estates.
Thank you.
You're welcome.
So I'm just going to start by giving a little bit of background. If you could, please explain to the jury what is a will.
What is a will? A will is a written document that's designed to be the legal declaration of what someone wants to happen to that person's property when that person dies. And it can also cover other matters. For instance, if the person has minor children, it can name a guardian for those children.
And does a will have to be drafted by an attorney?
No, it does not have to be drafted by an attorney.
Who can draft a will?
Virtually anyone can draft his or her own will. Mm-hmm.
And what are the requirements for the will to become a legal document?
Basically, the will has to, first of all, exhibit an intent that it be a will. And often people will just say last will and testament, things like that. It has to be signed by the person who wrote the will, who's called the testator. Sometimes you'll hear the term testatrix, but it's the same term. And then it has to be signed by 2 witnesses who signed the will in the presence of the testator.
And you said you'll hear sometimes testator or testatrix.
Right.
And what's the difference?
The testatrix is the female version of it in Latin, and so for a long time that was the term that people used when the person writing the will was a female. Most of the modern statutes tend to just use the generic term testator.
And is there any requirement that after you draft your will that you have to have this blue paper backing on the back of it?
No, that blue paper backing, or sometimes it's a white paper backing, it's usually put there by an attorney who drafted the will. It makes the will look more official. It's obviously easier to recognize so people won't get it mixed up with their other papers, but there's no legal requirement that it be there.
Okay. And after you, I guess what is it called? After you draft your will and it's witnessed by 2 people and you sign it in their presence, what is the term for that? It's called execution.
Execution and attestation, yes.
Okay. So after you execute a will, do you have to file it at probate court?
No, well, as long as you're alive, you do not. Now, there's the possibility that you can. The probate courts will allow you to, but most people don't do that. They either keep the will in their possession or put it someplace safe.
Okay. And when you say put it someplace safe, you can keep it like in a safe at your home or at your office?
That's correct. You could keep it in a safe. Mm-hmm.
You can just keep it in a drawer if you want it?
You could keep it in a drawer.
Okay. If you could, please explain what are some of the reasons that people typically change their wills?
People change their wills. People change their wills when there's a change in their own life circumstances. Maybe they get married, they get divorced, things like that. They might change a will if they've decided they don't like the people named in the will and they want to name somebody else. Or maybe somebody new has entered their lives and they would like to put that person in the will. Sometimes they just change them for the sheer reason of updating the will, making sure they'll check probably with an attorney to make sure that the laws are still the same that they were when the will was drafted. Sometimes there are tax law changes that cause people to change wills.
And how can, after you've executed a will, how can you revoke a will?
You can revoke a will either by doing what's called a physical act, which would be like tearing it up or burning it or scribbling all over it. And the nature of the act is not that important. What's important is that you do that act with the intent to revoke the will, because sometimes things get destroyed by accident. So you have to have the act plus the intent. Or alternatively, you can write a new will that revokes all of your other wills, or you can just write a document that says, I hereby revoke the will dated such and such. And I should probably add that there's some things that will cause parts of a will to be revoked automatically. Like if you get married after you have signed a will. Unless you mention that in your will, then that will would be revoked to allow your, at least in part, to allow your spouse into the will.
Okay. And when you say it could change after you get married, when you say to allow your spouse into the will, what exactly was that?
Well, for example, if I have a will that leaves everything to my mother, and then I get married, then the will, in a sense, is going to be completely revoked because it's going to bring my spouse in to take what he would take if I died without a will. And if I have no children and a spouse and I die without a will, by intestacy, that's when you don't have a will, my spouse would get everything.
And how do you pass property under a will?
How do you pass property under the will? Well, you can write several, take several different approaches in your will. A lot of times people have specific things that are very important to them, and so they will specifically name those things in the will, and that's called a specific bequest. Sometimes they will just pass an amount of money to somebody in a will. That's called a general bequest. Sometimes they'll pass an amount of money from a particular source. That's called a demonstrative bequest. And then some people just throw it all into one pot, and they call that pot the residue. The residue is everything that hasn't been specifically dealt with already in the will.
Okay. So I could, if I had the ranch I wanted to leave, I could say, I leave this ranch to, and I could say Austin.
Correct.
Or I could say, I leave my entire estate to my residue, and I leave my residue estate to Austin.
Correct.
Do you have to own the property before you can give it to someone else in your will?
Right, and not only do you need to own the property, you also need to own the property in a form where other law doesn't control. I don't know if that makes sense, maybe an example would help. For example, I have a retirement plan and I own all of the assets in my retirement plan, but I have a named beneficiary on that plan, and that beneficiary will end up taking, no matter what I say in my will. So there's some other laws that will cause things to pass. We call it passing outside of probate, outside of the will.
Okay. And can you leave property to someone that is not a relative?
Yes. Mm-hmm.
And is there a law in Georgia that requires you to leave your property to your children?
No, no. There is a law that allows, if I die with minor children and I've cut them out, and the same with the spouse. It's something called years support. It allows them to apply to get support. Yes, called years, Y-E-A-R, sorry, apostrophe S, support, S-U-P-P-O-R-T. And it allows them to apply for a year's support from the estate. But I'm not required, nor is anyone in Georgia required to leave property to a child or a spouse.
Now, if you could, please explain the probate process and what happens when someone passes and they have a will.
Okay, assuming that the will can be found, what will usually happen is either the executor or the executor's attorney, and the executor, by the way, is the person who the testator named in the will to take care of his or her property. So usually the executor, it could be somebody else, will take the will down to the probate court. And the probate court will require that any heirs of the deceased person be notified. And the heirs are the people who would take if the will is not valid or if there weren't a will. So they'll get notification. The witnesses might have to appear either at the probate court or sign an affidavit that said that they witnessed the will. And the concept here is that the probate court is then going to examine the will, make sure it's the appropriate document, make sure it is the last will and testament of the person that it's supposed to be the last will and testament of. And then when the probate court determines that, then the probate court gives the executor a document that's called letters testamentary, and it's T-E-S-T-A-M-E-N-T-A-R-Y, letters testamentary, which is the document that the executor can now use to go and collect all of the assets that belong to the person who died.
And what is the difference between the executor and the trustee?
Okay, the executor, again, as I said, is the person who's named in the will to take care of the estate. Not every will has a trust in it, and there could be a trust that's separate from the will. both of those, whether it's in the will or separate from the will be administered by somebody called a trustee. And usually the executor's job is fairly short, maybe a year, maybe 18 months. But a trust can last for a long time. So the trustee's job is to manage the trust property throughout a long period of time, maybe the lives of several people or through a certain number of years. And so the trustee's job is a little bit more complicated. The trustee has to invest the property and also decide when property goes out of the trust, when it gets distributed.
And how long typically is the probate process, considering there are no contests to the will?
Okay, if it's a simple will and there are no contests, and by the probate process, I'm assuming you mean from start to finish of administering the estate. It's hard to say exactly, but I think it would be fair to say around a year is average.
And in addition to the will, are there any other documents that are required to start the probate process?
There's a form that the probate court requires you to use, but basically you just have to have the will itself in terms of documents that you bring to court.
Okay. And if you could please describe what happens if we have someone who dies, and we have a friend that says, I know she had a will, but the will can't be located. What happens in that process?
Okay, in that process, first of all, the statutory law says that if you can't find the will, then the presumption is that it was revoked. That is, the reason that you can't find it is because it's presumed that whoever's will it was tore it up, got rid of it, didn't want it anymore. But that's just a presumption. And what can happen is that either witnesses or maybe documents that are copies of wills can be brought into the probate court. And if you can, what they call, overcome that presumption, if you have a preponderance of the evidence that you can prove that there was the will, then the will can, in fact, be probated, even though you don't really have the physical copy. But you have to start by knowing that if you don't have that physical copy, you've got a pretty tough road ahead of you.
Okay. And after a will is executed, can you change it orally?
No, you cannot change it orally.
Now, in preparation for your testimony today, did you review some documents that were provided to you by the state?
I did.
I'm going to show you State's Exhibit number 147-20, State's Exhibit 441, State's Exhibit 445, and State's Exhibit number 446. They've already been introduced into evidence. Did you review these?
Yes, I did review the bottom half of State's Exhibit 147. I reviewed 441, I reviewed 445, and I reviewed 446.
And what is State's Exhibit number 147?
State's Exhibit 147 is a series of emails back and forth between Mr. Hudson, Mr. McIver, and Ms. McIver relating to conversations that Mr. and Mrs. McIver had with Mr. Hudson about writing new wills.
Okay, and what's the date of that?
Well, let's see, there are 2 or 3 emails on here. Off the top, we have one dated August 2011, and then on the bottom half, we have one dated July 1st, 2011.
And what is State's Exhibit 441?
State's Exhibit 441 is the last will and testament of Diane S. McIver.
And do you know what year that will was executed?
It was executed on February 1st, 2006.
Okay. And State's Exhibit number 445?
That's the last will and testament of Claude L. McIver III, and it was executed on December 6th, 2005.
And State's Exhibit number 446?
That's also called the last will and testament of Claude L. McIver, and it was executed on March 16th, 2004.
And after reviewing the documents, did you prepare a report with regards to the emails from 2011 and Diane's will from 2006?
Yes, I did.
And I'm going to show you what's been marked as State's Exhibit number 273. Could you review that for me?
Yes, I believe that's the copy of the report that I prepared in January of 2018.
Okay, and do there appear to be any alteration or deletion to your report?
No, they do not.
Your Honor, permission to introduce State's Exhibit number 273 and publish?
Any objection to 273?
I don't object to it being read. I would object to publishing it or having it go back to the jury.
We wouldn't ask for it to go back to the jury, but I believe her testimony was called for.
So she should just testify.
And that's fine.
Not
Okay.
publish her report.
I'm in agreement. If there's a chart or something that's going to aid in presentation, you could flag that for Ms. Clark-Palmer. But otherwise, as long as Professor Radford's letting us know when she's looking at it to refresh her recollection, she's free to look at it. It's admitted, meaning it's been made part of the record.
And Ms. Radford, was a demonstrative prepared to aid you with your testimony today?
Yes,
And I'm showing you at the Market States Exhibit number 451. Did you have a chance to review this?
I did.
And did you adopt this demonstrative?
There are parts of this demonstrative that I'm familiar with, and then there are parts that I was not asked to opine upon. So basically the top part is the part that I'm familiar with, and so I will adopt that.
Okay. And Your Honor, permission, and we'll use in this demonstrative aid in your testimony.
Yes.
And Your Honor, permission to use State Exhibit number 451 to assist in the testimony of Ms. Radford.
Ms. Clark-Palmer.
I have an objection as to relevance because it makes a reference to Mr. McIver's 2004 will.
Why will we be talking about the 2004 will?
I believe in the testimony of Ms. Schwab, there was testimony about Robbie and his desire about the ranch, and it was illustrated.
Okay, so it will be a surgical inquiry into the 2004 that you believe is relevant, and we can revisit relevance when we see what aspect of it. Given that ruling, is there still an objection to 451 as a demonstrative aid?
Yeah, I'll just maintain my objection.
Okay. I have a question. Professor Radford said she didn't adopt part of it.
Yeah, and I will cover up.
You'll cover that. All right. The part she's adopting, you may publish.
And you reviewed the defendant's 2004 will.
I did.
And in the 2004 will, did he mention ranch?
He did. May I refer to my copy of the 2004 will? It's a little bit complicated. Yes?
Yes.
Okay. All right, in the 2004 will, he did refer to, now you're calling it the ranch. This is called My Farm at 603 P Ridge Road. Are we talking about the same item of
Yes.
property? Okay. And would you like me to talk about what he said about it in there?
Yes.
Okay. So we have on here that it goes to Robbie. Essentially, that's a little bit simplified. The first thing that happens is he gives what's called a life estate to, quote, my friend Landa Diane Smith. And a life estate means that she can live in the property and use the property for the rest of her life. And he also gives her an option to purchase it. But then if she does not survive him, and presumably at her death, though this will is not completely clear on that point, then all of his property ends up with Robert M. McIver. And I'm assuming that's who you mean by Robbie. Is that correct?
And in 2004, who owns the ranch?
In 2004, as far as I know, Mr. McIver owns the ranch.
And could you please describe to the jury what is fee simple?
So he presumably, again, owns it in fee simple, which means it's all his. He can do anything he wants with it. He owns all the present interests, all the future interests. It's the best form of ownership that you can have.
And, okay, and did you review the 2005 will?
Yes, and once again, is it all right if I look at my copy of the 2005 will?
It is.
Okay. Did you have a question?
And in the 2005 will, who does the defendant pass the ranch to?
Okay, in this will, in item 3, he gives all of his interest, so not just a life estate, but all of his interest in 603 P Ridge Road to Landa Diane Smith if she survives me.
Now, when he owns it in fee simple, he can pass it to whomever he wants to pass it to in his will.
That's correct.
In 2005, after he and Diane get married and they own the property as joint tenants with rights to survivorship, can he pass it to whomever he wants to in his will?
No. Now, owning joint tenants, people owning property as joint tenants with right of survivorship is a little bit different. And I'll just try to give it maybe a simplified version of it. Let's say we have two people who are joint tenants. Both of them own the property while they're alive, and both of them can use it, and both of them have access to it. It basically is their property. But when the first of them dies, that person's interest disappears. So it becomes the sole property of the remaining person. And there can be more than two joint tenants, but I'll just use those two as an example.
Okay. And when you say there can be more than two, would there be on a deed? Will it list all of the tenants?
Right.
Okay. And when someone gets married, let's say, well, he owned the property before he married Diane, and then they got married. Did he have to give her a right in the property as joint tenants because they got married?
No, he did not.
So there's no requirement for that?
Correct. I'm not sure I answered your question, though, about joint tenants with right of survivorship. I think maybe you had asked me whether you can pass property through a will if it's held that way, and you can't. In other words, when they're now holding property as joint tenants with right of survivorship, the will no longer controls. It's the property law that says whoever dies first, that person's interest disappears, the other person owns the property.
And in the 2005 will, does the defendant make any provisions for his son, Robert or Robbie?
So you're switching to one will later now?
Yes.
Okay.
Okay, so, and we're in the 2005 will, right?
Yes.
Be clear, okay. In the 2005 will, yes, he gives the residue of his estate to his son, Robert McIver. And so that would be after any specific bequests have been made, after any debts have been paid. The residue will go to Robert McIver if he's alive, and if he's not, to his descendants.
Okay. And then in Diane's 2006 will, what does she indicate that she wishes to happen to the ranch?
Okay, so I'm looking at my copy of Diane's 2006 will. Item 3 says, she talks about the same description of the farm and all of its furnishings. I give, devise, and bequeath to Claude L. McIver III if he survives me.
Okay. And do you know what's the date on her will? I'm sorry if you could repeat that, please.
The date of execution was February 1, 2006.
Okay. And if they own it as joint tenants with rights to survivorship in 2006, can Diane leave that ranch to anyone else?
No, not in her will, no.
Okay. And if the defendant predeceases her, what happens to the ranch?
If the defendant dies first, then she is the sole owner of the ranch.
Okay. And in her will, where does the ranch go after she dies, if he predeceases her?
If he died, I'm sorry, I didn't understand your question.
If the defendant predeceases her and then she dies, what happens to the ranch?
Okay, then if the defendant predeceases her, basically what's happened is that her specific devise of the ranch has now become part of the residue of her estate. And in item 6 of that will, the residue is actually put into a trust. So this is one of those wills that has a trust built into it. And Kenneth W. Rickert is the trustee. The trust is designed basically to take care of Mr. McIver during his life, that is, give him income during his life. But in your question, you said, assuming he's already dead, then at his death and at the death of two people who are named to receive some education benefits, then the trustee has the discretion to choose one or more charities that will take whatever's left in her estate.
Okay. And in Diane's 2006 will, does she ever make any provisions for Robert McIver or Robbie?
I saw no provisions for Robert McIver. The only place that I could think he would possibly get something was, she does have an item in her will where she says, I might leave a list of items of personal property and people to whom that property would go, but that's not legally binding, and she certainly does not name him in her will.
Okay. And you reviewed the draft emails. Did you ever see a will from 2011?
No, I did not.
It was just emails between the defendant, Ms. McIver, and Harold Hudson.
That's correct.
Okay. And in her draft of, in her suggested changes, what happens to the ranch at her death?
Okay, and again, I'm looking at my copy of the July 1, 2011 email, and it's got a list of Diane's new will and everything that would happen under that will, and then Tex's new will and everything that would happen under that will. And number 3 under Diane's new will says, the farm passes to Tex, but if he is not alive, it passes into a trust for Austin.
And what does that mean?
That would mean, again, if Mr. McIver survived, then he would get the property outright. That's once again assuming, though, that she has an interest that she can pass through her will.
Okay.
And so it seems that that probably is not even the case, so we might not even need this. But anyway, if Mr. McIver does not survive her, then the property is going to go into a trust for Austin. And a little bit later down in item number 12, she talks about a trust that is going to take care of Mr. McIver and, quote, Austin's education broadly defined. And that's about what I know about the trust.
Okay. And in 2011, they still own the property as joint tenants as rights of survivorship. She cannot leave the ranch outright to Austin.
Correct.
Okay. And if she wanted to make sure that Austin got the ranch, would these suggestions allow her to accomplish that?
As long as they own it as joint tenants with right of survivorship, no. These suggestions would not allow that to be accomplished, no.
Okay. And what about for the defendant? If he receives the ranch, is it required that he would have to give the ranch to Austin?
No, because again, this will is these proposed wills are not going to be able to control what's going to happen to the ranch.
Okay. And in Diane's 2011 draft of the proposed change to her will, does she make any provisions for Robbie or Robert McIver?
I don't see any provisions for Robert McIver. The only thing, again, I see is a reference to that list I mentioned before, that list of personal property.
And what about the defendant? Does he make any provisions for Robbie or Robert McIver?
He does. He leaves the remainder of his estate to his son, Robert. And if Robert's not alive, to his children. That would be Robert's children, I'm assuming. And if neither are alive, then he leaves it in trust for Austin.
And did you see any wills from either the defendant or did you see any wills from Diane from 2006 to 2016?
No, this was the only will of hers that I saw, the 2006 will.
What about the defendant? After 2005, did you see any other wills from him?
Yes, she supplied me with a copy of a will dated 2016, October 19th, 2016. And again, I'm referring to my copy of it.
Okay. And in the 2016 will that was executed by the defendant, what happens to, is the ranch listed specifically as a bequest to Austin in that will?
No, there's only one specific bequest in that will, and it's not the ranch.
And what is that specific bequest?
That specific bequest says that at the time he's writing the will, there's a life insurance policy on his life for $750,000. And he says, if the proceeds of this life insurance policy are paid to my estate, and that would, of course, you'd have to look at the life insurance policy to make sure that happened. But if they are, and my son Robert survives me, I give him $500,000 of the $750,000.
Okay. And what does he say about the ranch in that will?
He doesn't mention the ranch in that will. He just after that, that's the only specific bequest. Then he goes down to disposing of the rest of his estate, the residue of his estate.
And what happens with the residue of his estate?
Okay, again, this will is not completely clear, but he starts in item 6 by saying, if I'm survived by my godson, Austin M. Schwal, then the entirety of my residual estate shall be apportioned for him. And then it goes on and says, if it doesn't survive me, then the residue is divided into shares for Austin's children, or if he has any grandchildren, living grandchildren, things like that. And then it says in Part A, the share apportioned for Austin shall be held by my trustee as a separate trust, under the provisions of Article 7. But in Article 7, he doesn't specifically refer to holding the property in trust for Austin. As I said, it's a little bit confusing. In Article 7, he describes the trust being used to benefit the beneficiary, but he says, this is the way Article 7 starts, if the trustee is directed to hold assets in a separate trust under this article for the benefit of a child of Austin M. Schwall, his child or children, then this is how the trust would play out. I'm assuming that what the drafter probably meant, though I have no way of knowing for sure, but just having read a lot of wills that weren't completely clear, is that Austin's trust would be following the same guidelines that are here.
Okay, but there are no guidelines for Austin's trust delineated in that will.
Well, it says, in Part 6 it says refer to Article 7, but then in Article 7 it doesn't refer to Austin.
Okay. Now, in 2006, after Diane passed on September 26, 2016, he would own the ranch in fee simple.
That's correct, assuming again they held it as joint tenants with right of survivorship at that time.
So he could have put in his ranch, in his will, I leave the ranch to Austin.
Yes.
And if you could please, if Diane owned that ranch in fee simple, could she give it to Austin?
Yes, if she owned it in fee simple, she could, do you mean devise it in her will? Yes, she could devise it in her will to Austin.
And do you know what would happen to the ranch if Diane had a lien or a mortgage on it and she foreclosed on it?
I'm not really an expert in foreclosure and real property law, so I won't try to answer that question.
Okay. And could you just explain to the jury what the Slayer statute is?
Just review my objection for the record, Your Honor. I objected as to...
No, I'm remembering. I'm just processing how that all went. Okay. Overruled.
Could you please describe to the jury what the Slayer statute is?
Okay, the Slayer statute is kind of a slang term, if you will, that we use for a statute that's in the Georgia Code, and it's in the title of the Georgia Code relating to wills and to decedent's estates. And it basically says that if one person feloniously and intentionally kills another person, or attempts to have that person killed, or procures the killing of that person, that the slayer, the person who did the killing, cannot take from the estate of the individual who was killed.
And so the Slayer statute, if it's a felonious and intentional?
Right, and in the statute it says that if the individual is found guilty or otherwise proved to have committed murder, felony murder, or voluntary manslaughter, that would be a felonious and intentional killing.
So that means that they could not take under the will.
Correct.
And
Actually, it would be killing the testator instead of killing the beneficiary.
beneficiary.
Oh, sorry.
I'm sorry. So if I am left something in your will and then I killed you, I could not benefit from your will.
Assuming it was a felonious and intentional killing, yes.
And does the Slayer statute apply to property that is not passed in the will?
The Slayer statute is not completely clear about that. The second section of the statute talks basically about intestacy, which means if you die without a will, you can't take, even if you killed your person you were to inherit from. It mentions the word deed, and it talks about other conveyances that were executed by the decedent. So I have never seen it applied to a joint tenancy with right of survivorship, and frankly, I think we probably need to leave it to a judge to figure out if it does apply in that circumstance.
And once the defendant's 2016 will was executed, he could change it at any time.
Yes, you can change your will anytime up until death, so long as you still have capacity.
No other questions?
Thank you.
So Ms. Clark, is it going to be Ms. Clark Palmer? Yes, because you were objecting. We once again reached cross-examination. We're at a point where we could break. Okay. It's lunchtime, folks, and it's 12:45. Let's be back at 1:30. Dr. Radford, I'm sorry, we're gonna do get lunch too, but can't get you out of here free lunch. We need to make sure there is a thorough and sifting cross-examination as well. And that will start around 1:30 today. Enjoy lunch. Don't talk about the case. Don't talk about wills and trusts or anything like that during the break. Talk about something else. Or don't talk. And we'll see you at 1:30. Juror 61, we're working on the letter, and Juror 5, I need you to come right up here after Ms. Radford has gone on her way.
All rise for the jurors. Please be seated.
All right, Professor Radford, we'll see you back here a little before 1:30. Talk about your testimony with anyone during your lunch break, okay? All right, you all sit tight for a second or stand tight. Okay, before we break.
Just renew my objection to Ms. Radford's testimony to the omission of the emails about the 2007 will, where I think we're going with Mr. Morse. There's zero evidence that Diane McIver intended to foreclose on this property, that Mr. McIver thought she was going to foreclose on this property.
Who's Mr. Morse?
The real estate guy who's coming, who's going to talk about right to foreclosure on.
Oh, right, because everyone's been saying I can't answer the question
Right.
about how you foreclose.
So what is the relevance to motive? Is it that he was going to kill her to keep her from changing her will? He was going to kill her because she changed her will, and then he went and shredded it? Respectfully, I think we are wasting our time going through all of this with her, with Mr. Morse, looking at these emails from 2011. So I just removed my objection.
Okay. Why are we going to hear from Mr. Morse? I overrule object. I think this has been very helpful and relevant and whatnot from Dr. Radford in terms of how wills work. Wills are clearly at issue here. Existing wills and theoretical wills.
What also is an issue like the state contends is that there are two promissory notes that are secured by this ranch. She talks about there's no evidence that she intended to foreclose. The state can argue that the fact that she secured her promissory note by this ranch and gave her the option to foreclose shows her intent to foreclose. I think it's completely relevant because he could lose ownership of the ranch had she done so.
So Morse would be limited to coming in here and saying, based on the language of this promissory note, because really it's the only one in effect at the time things happen that matters, this promissory note, here is what Ms. McIver could have done if she called it, 90 days notice and it wasn't paid, or there was a failure to pay, someone was late, etc. And this is what Ms. McIver could have done.
That is it.
Okay.
And just as a factual basis, now what we know is that the day after his wife died, he told Kenneth Rickert, hey, we're talking about restructuring our finances by the end of the year, and I'm making less money and the ranch expenses are still up. So, you know, there's a little bit more there.
Okay, I think there's an argument to be made that that was top of mind. Okay, I'll think about Morse some more, and we can discuss Morse again. If you don't think Dr. Radford's relevant, you don't need to ask any questions on cross, but we'll tee that up for you to do when we get back, and we'll keep moving along. Other things?
Just note that none of that argument tied into anything that are in these emails from 2011.
Well, fair point, but you drew a larger portrait of what's frustrating you about not being relevant, and that included the foreclosure option, if in fact that's what the secured note would have allowed Ms. McIver to do, and Morse is just about that, and nothing more. Professor Radford had testimony that I felt was relevant concerning those discussions in 2011. Your relevance argument there, I take it, is it's so remote to be irrelevant. It's not 2012 right now, it's 2018, so that's 7 years ago, although more relevant would be a more germane. It was 5 years before the incident that brings us together.
And what's the effect on Mr. McIver? That's what is it? He killed her, the state's theory is he killed her to keep her from making these changes, or he killed her because she made the changes, but there's no effect on him.
Okay, so you maybe want to make it a tripartite closing argument, because you clearly have some strong feelings on that front as well. But the state's going to argue what they argue, and I have found and continue to find that what we have heard from Dr. Radford and what little bit I've been told we'll be hearing from, I don't know if it's Professor Morse or Mr. Morse or what, is something I'm going to allow. Okay. All right. Let's be back at 1:30.
I don't think we're done, sir.
Oh, I'm sorry, Mr. Harper.
Not this case, can I just come up?
Yeah, I won't run out, but I want to let folks go. So we are taking a lunch break, quarter